Okay, we have our system on. I have the following announcements for this morning. Pursuant to Government Code Section 54956.9C, conference with legal counsel, anticipated initiation of litigation, one case. By a unanimous vote with Supervisor Tryon abstaining, the board authorized County Council to file suit on behalf of Calaveras County against the 39th District Agricultural Association. Secondly, under closed session last week, we had conference with legal counsel, anticipated litigation, significant exposure to litigation, one case pursuant to Government Code Section 54956.9B. One, no action was taken. And then thirdly, public employee appointment pursuant to Government Code Section 54957, Planning Director, no action, and that item was continued until the board meeting today, and we will be meeting yet again in closed session on that item today. Also, we have a cancellation of the February 1st, 2011 board meeting. So that completes the announcements. We move forward to the consent agenda item. These items are expected to be routine and non-controversial. They'll be acted upon by the board at one time without further discussion. Any board member, staff member, or interested member of the public may request that any item on the consent agenda be removed for further discussion prior to the board's taking action. Does any board member wish to pull any item on the consent agenda?
I do.
Okay, what is it?
Item number 14.
No, consent agenda, items 1 through 4.
It was previous minutes.
The minutes?
Mm-hmm.
Okay, any other board member? Any staff member wish to pull any item on the consent agenda? Any member of the public here present this morning have any item on the consent agenda they wish to have discussed with or by the board prior to the board's taking action? Joe? 4? Okay. That's fine. I have 4 circled. Any other public member? Seeing none, I'll bring the consent agenda back to the board and entertain a motion on the balance of the consent agenda as presented.
So moved.
I have a motion by Supervisor Tofanelli.
Second.
A second by Supervisor Walensky. Do I have further board discussion? All in favor so indicate by stating aye.
Aye.
Opposed? Passes on a 5-0 vote of the board. We'll go back to the minutes of the regular board meeting held on January 4th, 2011. Darren?
There was an item 14.1 for acceptance of Assessment Appeals Board appointee, and I'm asking for that to be stricken from the record for future discussion with County Council.
Why don't we just continue the minutes then? I think.
Well, the question I would have is the record accurate as to what we did, and are you asking us to change a position on it, or are you saying that the record is not accurate and needs correction?
The record is accurate as it was recorded, however, it needs to be changed.
So you want an item changed?
That's correct. So I don't want to approve the minutes of that action.
Well, I believe you're asking for an action to be reconsidered. Am I correct in that interpretation?
I am. Preemptively, I'm asking for it not to even be approved as a recorded minute.
The approval is in the action, not in the recordation of it. So, in as much as the action has taken place, we need, if your desire is to have that reconsidered, we would need to actually take that action and do a redo.
We'd have to bring it back to the board if the minutes are accurate for what transpired on that date.
Counsel?
Yeah, I have to agree. I think there was a confusion because the chair said January 4th, and I think Supervisor Spellman is talking about the minutes for December 14th.
That's correct.
Well, this was for the January 4th minutes.
Well, Marita says December 14th and January 4th. Mine says just January 4th, and Gary says just January 4th.
So does mine.
As does mine.
So does mine. I mean, I already looked at the other. I looked at the packet earlier.
So this is.
Are we doing both minutes?
Yes.
I think the discussion is about.
Okay, and what is your issue on the minutes of which date?
December 14th.
December 14th.
That's correct.
Okay, so, and Jim, what is your,
Well, the only issues are the minutes accurate. I don't think it's possible to reconsider the item
already
in terms
voted.
of correcting the minutes. We can bring it back as a properly agended item.
okay,
Agendized
so
item for
is that
discussion.
acceptable?
Makes sense?
Okay, then I'll entertain a motion to approve the minutes of December 14th, 2010, and January 4th, 2011.
So moved.
Second.
I have a motion by Supervisor Callaway, a second by Supervisor Walensky. Do we have further board discussion? All in favor, so indicate by stating aye. Aye. Opposed? Passes on a 5-0 vote of the board. So you'll meet then, Darren, with County Council and
Yes, sir.
discuss your issue?
Yes, sir.
Okay, we will then, let's see, what are we, 9?
We have item 4.
Oh, excuse me, item 4, geez. Leave Joe off. Come on forward, Joe. A resolution approving the contract for use of juvenile correctional camp, Madera County. This is a probation issue. Joe, would you like to go over what your issue is?
Yes, Joe Kelly. I'd like to know how many young people you expect to house down there. I'd like to know why this county isn't looking into providing its own juvenile facility. Is it money? Is it space? Is it personnel to be able to do it? The concept of the old jail could probably be rehab for that purpose. That will be discussed during public comment. But I'm concerned also in this that this is going to be a resolution, and I want to be assured that all actions heretofore taken by the officers and agents of the county that are in conformity with the purposes and intent of this resolution are hereby ratified, confirmed, and approved in all respects. Is that true and correct? Is that what's going to happen here? Is that the usual bureaucratese that's used to when you do a resolution to sign on, and that it's an agreement done other than the sub-agreement with the agency you'll be dealing with?
Ask
It's
that
a
question
contract.
again, Joe.
Is
What is the
that
question?
language from the contract? Is that what you're quoting here?
No, I'm looking at a resolution, and it has that in it. So I'm looking to see if this is if this ratifies within the resolution. The resolution means a certain thing, that an agreement has been made by you folks, amongst you folks, and that it is put forth as to be representative of what we, the people, have to live with on the basis of what you've done. So I want to be sure that this is, in fact, an agreement.
Yeah, the agreements with the,
So it's a legal. The resolution is a legal. Once you agree to it, if it's a 3-2, 5-0, 4-0, or 4-1, whatever it is, that it is a legal agreement and it's ratified by your vote.
We are approving a contract is
Yes.
what's before us.
But under this state's resolution, and when you do a resolution, then your contract comes under that resolution, correct?
It's a resolution approving the contract.
Okay. And what I'm saying is the resolution also is approving the contract. The contract is an agreement, but the resolution also agrees to agree to that contract.
yes. I mean, what we are is approving the contract.
Okay.
With the resolution.
Okay.
Okay.
So
What's this?
the cost I saw was $125 per day. I think that came out to what, $13,000 or something like that a month
No.
per kid, somewhere in that neighborhood.
3,750.
3,750. Thank you. 3,750. So at what point does it become, and if you have projections of how many children or young people that are violators that have to be sent down there to serve their time, what is the projections on that, and what are you doing to look at as a future for benefit that within the juvenile justice system, something that is used is they want to keep the children close so their families can come and see them. If you're shipping them off to Madera, you're going far against and away from. So is there anything in the future of this county to look at a juvenile facility or the rehab of the old jail for that?
Well, I guess my answer would be I certainly hope not, because hopefully we won't have enough juveniles to justify such a facility. We do not. I'll turn it over to Jeannie, but I think we have very few juveniles that take advantage of this, and hopefully that will continue. I mean, you have to have a certain critical mass, and like and you say we're sending it to Madera, but they're taking ours because they're trying to get the critical mass to justify opening a facility. I mean, all the rural counties aren't going to have their own independent facility.
Correct, and it's also coming down the line that there's a very good possibility that you will see juvenile justice facilities closed. Paso Robles Youth Authority was closed. They've closed a whole bunch of them. There's only one or two big ones left, if that. So it's going to, if we continue to see the strife that's being put upon the state budget because of overspending, then we're going to possibly see that those types of facilities might be closed, and just like the prisons are going to be doing, sending the inmates or these young violators back to the counties to deal with. So should you start to be thinking about where you might be responsible to have to put them?
Well, Joe, we're always sort of looking ahead, but I don't think we're even near a critical mass in this regard.
Plus, we have a contract with Tuolumne.
Terry Hall, Chief Probation Officer, is here, and she can probably answer some of the numbers questions for Mr. Kelly. We don't have any plans to build a juvenile facility here. Tuolumne County is going to be building a juvenile facility that we anticipate utilizing beds there. You're right. We don't like to send kids to these camps. Unfortunately, sometimes it's necessary. But Terry, would you like to respond to Mr. Kelly?
If Tuolumne is going to be doing something and this county is going to be using, is that going to be
That's
under
correct.
a JPA or an MOU or a participatory
Well,
effect?
there will be an agreement of some form.
That's correct.
So,
Thank you.
I would also like to add, I've served some time on the Juvenile Justice Commission, and one of the things, Joe is right, that family connections are very important for these kids, but it's also equally true that quite a percentage of the Calaveras youth that is finding themselves in this condition are actually fleeing families where abuse has occurred, and there's some need to get away from those ties. It's a mixed bag and has certainly mixed approaches. We need to be flexible and wherever possible keep the kids that benefit from family ties closer, but also acknowledge that there are some people who really need to get away from very bad situations.
Thank you, and that brings up another subject. Has the county ever looked? I'm sorry, Supervisor Tryon, if you don't want me to speak, tell me shut up and I'll sit down. Just like I used to tell kids when I was doing diversion, sir.
Ask your questions, Joe.
Sit down. It was basically I told them to shut up, sit down, and pay attention.
Joe, ask your question.
Fine. Is this county contemplating doing a diversion program? The look on your face says, what's diversion? Is that correct?
I don't know what diversion program you're talking about.
Is a program that goes through probation, tied with the sheriff's department, that sets the people up that go in and have fights. Things that might be cited, might be something to unclog the courts where it can be worked out. And then there's someone that goes in and works the system.
Okay. Let Terry answer
Terry.
that. And then we're going to move forward.
Thank you.
Terry?
Good morning, Board. I'd like to address some of Mr. Kelly's issues at this point. Just to start from number one, he asked how many juveniles would we be contemplating sending to Madera County. Right now, we utilize 3 county camps in the state. One is at Singer, it's in Yuba County. We have one in El Dorado County, which is South Lake Tahoe, and then this would be our 3rd contract with Madera. These camps offer confinement. They offer structure. They offer long-term treatment for these juveniles. It's more structured than a boys, like a group home or a girls' group home. The Madera County would also offer a female element to it, so they can house females and males as opposed to just males. They're very valuable, and it is a direction that, as noticed through the press, that DJJ is going to be closing the detention facilities at the state level. And we will be utilizing these camps more frequently, I can assume, in the future. This is a situation right now with DJJ. We don't typically send juveniles to DJJ. We send them to county camps for treatment. That's been our treatment for the last several years since I've been with probation. We got away from using CYA or DJJ because of the cost involved. It was enormous cost to send juveniles to the state level for supervision. So the county camps fulfilled our goal in getting the juveniles rehabbed, rehabilitated, and back into the community. As far as how many do we have currently in these placement facilities, these camps, I'm pretty sure we have 2 or 3, not in Madera at this time because we don't have a working contract, but we are looking to send probably 1 or 2 that are waiting right now in the wings to be sent down to Madera. So we have 1 in Singer, and I believe we had 1 in El Dorado, but I'm not sure if that placement's still there. We do have, as far as the goal of building a juvenile hall in this county, a couple years back when Mike Krilitich was here, we were trying to work with Tuolumne County to be part of that juvenile hall and to have an MOU and a working contract with them. Due to cost and staffing, it just wasn't cost efficient for this county, and so it was an easier way for us to look at their situation and actually rent beds on a day-by-day basis. So we have an agreement with Tuolumne. It's nothing that's been finalized yet because they're still in the construction process, but we do plan to have 8 beds with that facility, which would meet our needs at this time because we are in our juvenile halls. We contract currently with El Dorado County Juvenile Hall. We contract for 4 beds. Those beds are full. We have all 4 of them occupied at this time. As a backup juvenile hall, we're using Nevada County, and I believe we have 3 or 4 children there. So we have a total of 8 children or 8 juveniles in custody. And so we anticipate that we would be able to meet the contract with Tuolumne County for those 8 beds. I'm sure I'm missing something. I didn't. As far as a diversion program, he mentioned diversion. We are working right now with the Sheriff's Office. The probation department is actively getting programs together. We have an alternative sentencing program for adults right now. We have the electronic monitoring, the pretrial release program. Starting in February, we're going to have a work program that's starting. We've used some extra salary savings to bring extra hire aboard to help us run those programs. They're very successful. We are seeking out to do the same for juveniles. I'm leaving for Monterey tomorrow to go with juvenile systems committee to try to think of alternatives for juveniles. So at the state level, at the county level, we're looking at the big picture. We're trying to develop programs at the county level, trying to find out what works, get evidence-based programs plugged in so we can treat these children, so we can treat these adults and get them back into our communities.
Thank you, Terry. Any board questions or comments?
Just one. I noticed in the board packet that the cost, the economics of this is roughly the same. That is, it costs us close to $125 a day to house people here, and that's also the cost of this contract per day.
Yes, that's
so
right.
So it's an economic wash.
Exactly.
With a better facility and more programs.
More programs, more structure, yes.
All right. Thank you.
Terry, I just have one comment. Under financing, one of the points there is not to know just that it's budgeted, but what the source of the funds is. Are these general funds, are these state funds, are these federal funds?
These are state funds through
State
JJC.
funds.
Yeah, we
so
have
there's no general fund
no
contribution.
These are
okay.
grants.
You need to make certain you put that down. What
Yes,
the
sir.
source
Thank
of the
you.
funding is, and then it's great to know that it's also budgeted.
Thank you.
The source of the funding is important. Okay, then the chair is open for a motion on item 4 as presented.
I just have a quick question.
Oh, excuse me, Chair.
For Ms. Hall.
Yes.
I was under the impression, based on conversations with people prior to this discussion, that the county was paying approximately $5,000 a month for each child. So when I did the math on this one and came up with $3,750 on a 30-day month, I was kind of excited because it's actually a cost savings. But I don't know if that 5,000 number was inaccurate.
I'm sorry, say that one more time.
I was told that the number was $5,000 a month per juvenile offender that we were having them housed at the Preston Youth.
At the Preston Youth?
Mm-hmm.
I can't give you that number. I don't know right off the top of my head. It's right around $5,000 or $6,000 a month.
Yeah.
Yes.
So when I saw this and I did the math, I thought, oh, great.
It is.
This is kind of a cost savings.
It is, and it is the programming because the county, the county camps are not as populated as the CYA, and the programs are much better at that level. So we anticipate better results.
Good.
Okay.
Thank you.
Thank you.
Thank you. Any other board comments or discussion? Chair is open for a motion on item 4 as presented.
I move the resolution approving contract for use of juvenile correctional camp, Madera County.
Second.
I have a motion by Supervisor Walensky, a second by Supervisor Callaway. Do I have further board discussion? All in favor so indicate by stating aye. Aye. Opposed? Passes on a 5-0 vote of the Board of Supervisors. Next up is item 5, public comments, 5 minutes per person, 15 minutes per topic. Comments shall be limited to the items of interest to the public that are within the subject matter jurisdiction of the board. Are there any? There we go. Public comments. Will you please, when you give public comments, please come forward to the podium. We are of record. And please give your name and then your comments, and please sign in.
Krista Thompson, Mental Health Services Act Coordinator for Behavioral Health Services. I have a few brief announcements to make, one of which we are looking for new members for our Suicide Prevention Committee. It's actually meeting this evening at 5 p.m. at Behavioral Health offices here at the Government Center right past the Red Barn. And we will be meeting every month on the 4th Tuesday of the month. And we're really looking for new members to help us reach out to our older adult population, our veterans, and those who are economically disadvantaged and may also thus be at risk. We have so far reached well over 1,500 people in our community through our information distribution campaign, letting people know about the risk signs and the resources that are available. And now we want to expand that initiative to those special populations that the committee identified as being at great risk. So that's my first announcement.
Can I have a question?
Yes, please.
What about youth, children?
That was the first population that we focused on. We are still continuing to be in all of the high schools, including the alternative high schools. We go about twice a year to talk to whatever classes, or typically the senior class, or we've gone to the peer counseling classes and the ROP classes to train them on how to identify the risk signs and what they can do as young people to be champions for suicide prevention. The second announcement, kind of dovetailing on the previous discussion, Behavioral Health Services is actually collaborating with several law enforcement agencies, including probation, the Sheriff's Department, CHP, Angels PD, the Public Defender, and I'm probably leaving someone out, but we are working on a sequential intercept model, which will help us identify and intercept those who have substance abuse and mental health issues, and help provide services to them and potentially divert them from the system if at all possible so that they can get appropriate services. This is a process we've been working on for a couple years now, and we're really honing that process down, and we should be able to come up with a viable solution for this county. I understand that our director is also working on contributing input on the jail of how we can make that possible there as well. So that's my second announcement. And my third announcement, since it sounds like there's no meeting next Tuesday, is that we will be posting our annual update to the Mental Health Services Act plan to the Department of Mental Health. And we are posting that for a 30-day review period. And that will begin this Friday. And anyone is welcome to take a look at that. It will be posted on calaveras.networkofcare.org, or people may request that directly from me, and I'd be more than happy to get them a copy. We are continuing to fund all the programs that have proven successful thus far, and we'll continue to fund those at the levels that they had been funded at previously. And we've also added a couple new programs that I've talked to the board about, including our innovation programs, which will provide community support groups throughout the county, and our Garden to Families program, which has proven very successful in promoting the mental health of our consumers. We will be submitting that to the department in early March. There will be a public hearing at our mental health board meeting on March 1st. So if anyone has any questions about any of the topics that I've brought up today, please feel free to contact me directly at 209-754-6525.
Thank you. Before I take any more public comments, are there any staff that wish to give public comments? If so, I'll take those first so staff can go back to work. Seeing none, John, would you please come forward? Good morning.
Good morning. Yeah, well, here we are, another year of fun and games.
Yeah.
My name is John Rain, Rancho Calaveras. I wanted to speak briefly on two different items. The first one has to do with the public comments period time. After speaking to a few people, including my wife, I would like the board to consider leaving public comments time the way it is at the beginning of the meeting. And when controversial issues come up, extending that 15...
John, that's on the agenda. It's item 7.
Right.
So if you wish to address it, why don't you just hold on and we'll address it under item 7 since that's a scheduled item.
Oh.
Public comments are for things that are not on the agenda.
Oh, I'm sorry. I didn't read the agenda.
That's all right. You can be first up on item 7.
Yeah, the second item is a discussion we're having in CSA 1 about the possibility of maybe going to a CSD. And we believe that the current system that we're used to working with would be easier to do than the added cost, added people, running your own business type of thing you have with a CSD. I believe that would be most beneficial to that service area. Secondly, and just as important, we don't like to see county employees losing their jobs. And since we try to do anything we can in CSA 1 to get the county road department to do the work, we know where our money's going. We already have the people there to do it, and we want to keep county employees and the Public Works Department working by doing things the way we are now under the current CSA, rather than having to contract out to other out-of-area contractors to take care of road work. So that's our position on that CSA, CSD discussion that's going on right now. Thank you.
Thank you, John. Any other public comments? If so, please come forward.
Good morning, Mr. Chair, Honorable Supervisors. Al Segala, Calaveras County Taxpayer Association. Our group attended a conference or a summit that was sponsored by the Howard Jarvis Taxpayer Association recently in Sacramento. And at that conference, there was a number of things that was discussed. There were several forums, but there was one part that might be of interest to our taxpayers here and also this board. There were 6 principles that were expressed by John Coppell, the president of that association, and he asked that those county associations, those county taxpayer groups that agree with those 6 principles could stand behind him, which was before a press conference. And so during the press conference, those 6 principles were represented by quite a few groups. There might have been maybe 30 or more. And here's the 6 principles. California is a high tax state, and our excessive tax burden not only injures citizens and businesses, but puts us at a competitive disadvantage relative to other states. In addition to high taxes, California's regulatory environment is the worst in America. These excessive regulations impose hidden taxes on goods and services, and, as with our tax burden, puts us at a competitive disadvantage. California has a spending problem, not a revenue problem. While taxpayers generate tens of billions of dollars in tax revenue, we do not receive good value for our money. As just one example, California pays nearly twice the national average to incarcerate one prisoner for a year. Many of the problems associated with California's fiscal problems are directly related to the inordinate power of the public employee unions. That power needs to be curtailed so that elected officials may represent the interests of all their constituents, not just this one special interest. California has excessive debt, especially with regard to public employee pensions. Major pension reform is absolutely necessary for California to begin to recover economically. From the perspective of the taxpayers, any official who supports placing a tax increase on the ballot is expressly supporting that tax increase. That concludes those 6 principles. Our county association is interested in the CalPERS problem, and we had a meeting with public officials, which was a mixed blessing. We didn't learn very much. We learned a lot about what the county's approach is, but we weren't able to get basic questions answered about what the county liability really is on the CalPERS. We're going to pursue this further and keep working on it, and also work with CalPERS to get information from them. The county is not as much in control as we first thought. A lot of this is really controlled by CalPERS, and so we intend to proceed with that and perhaps be of some help. Thank you.
Thank you. Joe, you were standing up. Oh, Peter? We'll go with you.
Gentlemen, my name is Peter Reyes.
To you, Peter?
Valley Spring. Good morning, everybody. It's so nice to see you all. What I'd like to request from you folks is if maybe you can help idiots like me out in the boondocks to help me get a little bit more open and transparent policies and the way procedures, okay? I would very much like to see if we can somehow enhance our understanding of the sources of the funds, because just the name of grant doesn't do it, okay? The sources of the grants and who is going to be the eventual liability of paying for those municipal bonds or grants and so on. And I'd like to see if we can get a little bit more clear understanding of the recipients of those funds. It's nice to have a nice general name for it, but I'd like to attach some, like when you guys go take a trip, I don't care if it's San Francisco or Washington or Gettysburg or Monterey, whatever, but I would like to see if you can appreciate the hard work and the great knowledge and wisdom you're acquiring on those little trips to share it with us, because you're doing it in taxpayers' fund. You're seeing some very distinguished and bright individuals along that line. I sure would appreciate if you could take your time and write a report. But we will be really, so we can really appreciate the work and effort you folks put out, okay? That would be very nice, okay? And matter of fact, if ever majority of you board decide to do some get-together, whatever it's lunch, dinner, whatever, and since it's a majority of you, since it is the majority of you, so eliminate the a possibility of something, an apparent or actual violation of any laws that might come involved in it. So that we can really appreciate your hard work that you do here and every place else. Because I know you, some of you, 3 of you going up for re-election, if you decide to seek, that it can be brought forward down the road what great amount of sacrifices you folks make. And I want to know on whose dollars you're making it. And I want to know who's recipient of those sacrifices. And I want to compliment you folks helping the California economy. That $42,000 for bicycle construction. Unfortunately, you must obviously don't think that our sheriff's department has nobody qualified to do some instructions, you know? I mean, but I know that fund is helping a different county, and that was money you had to do something with it. And so it could be appreciated if some of these funds used locally. Now, if you feel that the sheriff's department doesn't have the knowledge, expertise, or qualification, that's really sad. Now, looking at the firm who was doing it, and in their little webpage, nowhere do they say they have any expertise in bicycles. Bicycle teaching, distribution on area of the tax funds. So, I mean, I appreciate so much what you folks doing that if you need help, maybe some of us will help you out. So, whatever is your choice, and this is out of courtesy to encourage you to come and inform us and teach us and educate us from all the great wisdom you're acquiring other places. Thank you, folks.
Thank you.
Morning. Marty Crane, Valley Springs, Rancho. Today I'd like to address the level of honesty we all bring to this process. First, Mr. Spellman, let's talk about your orientation. You couldn't wait till the 20th when everyone else would be sworn in. You insisted on the 14th. You were told the Bible wasn't customarily used in these ceremonies, but you could certainly bring one from home. You showed up without one and sent staff all over Government Center looking for one. They returned, Bible in hand. The swearing in continued. Then you took the opportunity to speak to the audience with the Bible in hand and proceeded to inform them that you brought this family Bible from home as a symbol of your commitment to uphold your office and the decisions to be made. You either brought it from home or they went on a field trip looking for it. I don't know. You did not bring it from home. You, in fact, used staff time, which is money, by insisting on the 14th and then by sending them on a search and retrieve exercise. They were on the clock. You also made it clear that it is your belief that the Constitution was founded on Judean Christian principles, that other religions do not enjoy the same course of support, but instead we tolerate them. Such arrogance. Who are you to marginalize other faiths or belief structures and profess that we are merely to be tolerated? While those working on the development of our Constitution may have in fact been of a Judean Christian belief, I believe they were serious about protecting the rights of all Americans to believe or not as they choose. Our Constitution and governing bodies represent all Americans, not just those who believe as you do. You recently attended a 5-day CSAC new supervisor training in Southern California. You made sure to let everyone know that you left after 2 days because Chris Rock was scheduled to perform, and you, Darren Spellman, were considering the appropriate use of taxpayer dollars by leaving after 2 days. Clarification. You were only scheduled for the first 2 days because those were the only 2 days that dealt with new supervisors. Had you stayed for the remaining 3 days, you would have had to been required to pay for those yourself. Honesty or accuracy with the facts does not seem to be one of your strong suits these days. So in closing, I'd just like to say, Mr. Spellman, tolerate this. I'll be back.
Any other public comments? Come on, Joe, get up here. No. I'm trying to get you up here, Joe.
My name's not Joe. My name's Terry, and I'm from Railroad Flat, and I'm here to talk a few things about, the Agricultural Dispute Resolution Committee. We turned in forms to the Agricultural Dispute Resolution Committee, and I gave one to everyone in here, and I read my response that went with my form to all the supervisors. On October 29th, I went to the Agricultural Dispute Resolution meeting, and everyone in that meeting had my form without the letter that was attached to it, explaining exactly what we were doing and exactly what we were wanting to do, and that letter was not with the form. Everyone got the form and was explained that it was something exactly opposite of what we wrote to go along with it. Now, it really pisses us off when we put our trust in people, and every time you do, you just screw us. And we're so sick of it, Steve. And then I've been told that, one of the reasons why we're letting this happen is because there was an expert witness that came out from the Agricultural Dispute Resolution who was not even supposed to be involved, because it takes two people to say to let you be involved, and since it was already in the court system, you overruled us and you brought an expert witness in. And she wrote a letter to the county saying that everything out there was perfect and fine and accepted. Did you read the letter she wrote to the Redmonds? It was exactly opposite what she wrote to the county, saying everything was perfect. The letter that she wrote to the Redmonds was, hey, man, this thing is really messed up. You got to do this, you got to do that, you got to do that. You can't let the birds run around wild because it's a biohazard, and it's a flat-out lie. The whole agricultural dispute resolution is a flat-out lie. Then we have the fact that everyone's saying this is accepted farming practices. Now, do I have to educate everybody in here? Farming is crops. Ranching is animals. Now, how can accepted farming have anything to do with animals? I learned that from Judge Moeni in court. Now, you can farm on 4 acres. You can have an accepted farming practice on 4 acres. But you can't have a commercial poultry operation. You need 20 acres for that. And all you got to do to find that out is to look in the permitted uses. It says right there, it is not permitted in RA zone, a commercial poultry operation. You can have a couple chickens, maybe a rooster, but not hundreds and hundreds. 3 years ago, when this expert was out there, there was 3 coops. That's what she saw. Now there's 18 illegal coops that need to have conditional use permits. Ken Church has said it was illegal and was wrong. So why don't you listen to that expert witness? Why do you pick and choose your expert witnesses and bring them in from out of town to overrule our local people? That's what the agricultural dispute resolution is doing. They're not doing anything by their rules, and they're not doing anything ethical. It's very upsetting when you know your neighbors are cockfighting. She puts it in her website saying that, you know, the winner, he's got the most blood on him, but it's not his blood, it's the other bird's blood. You know that's a felony in the state of California, just being a witness to a cockfighting operation or just a fight. That's a felony. And animal control, when I told them that, they said, oh, we're not going to cite her because she is not in a gang. What difference does it make if you're in a gang, robbing banks, or you just do it on the side on a weekend? It's still illegal. It's still a felony.
Any other public comments? If so, please come forward.
Will Moore from Valley Springs, ranching with Calaveras. I'd just like to add a little comment to what Marty said about the Bible. Our Constitution guarantees us freedom of religion. It also guarantees us freedom from religion.
Thank you. Any other public comments?
Bonnie Newman from Double Springs. 2 things. The Area 12 Agency on Aging, the workshops they're providing at the library, I think are exceptional. I attended one last week and received in paperwork information that we've never gotten from the county or the public authority or IHSS that is specific for care providers, and it's incredible. And I hope we can do something to replicate it because it's already been done by the Area 12, and very well, I might say. And they have 5 more workshops, and I'll leave this up here for anybody that feels they might want to attend. It was pretty full, but the food was good. So. The second thing I've been thinking about last week, the announcements that Jeannie was making about the budget and how it's going to impact IHSS. And I attended an IHSS advisory board meeting yesterday besides. And the proposal to eliminate funding for the IHSS advisory boards, I don't have a problem with it. I don't think the money's been used wisely in our county for the past 10 years. And Whenever I hear of somebody using the money for their own personal benefit, it just irks me. Now, I've complained before that they give themselves a $40 stipend to attend these meetings. And yet they struggle over paying for printing or postage. And now they found out that they can buy themselves lunches with IHSS Advisory Board monies. And that just left such a horrible taste in my mouth that they are going to do that, and took time to take a vote that they're going to do that. The funding may be eliminated, and it could have been used so productively for the past 10 years. It just kills me that there's a little bit of effort now to do something positive, and it's going to be eliminated. We have to remember the IHSS Advisory Board was not the last program or entity that was formed out of IHSS. The Public Authority was the last program that came out of IHSS funding. And if they think they're going to save $3 million a year by eliminating the IHSS Advisory Board monies, they, by eliminating the Public Authority, could save money, many millions of dollars. And I'm trying to justify the $200,000 and more we spend each year to employ 2 people to give providers training, which is lukewarm training, and to conduct a registry, which I bet matches less than 25 people a year in our county. And I have not been able to get that number, but I think there are many places we could save money in this program, but it sure isn't services. They're talking about eliminating additional hours, especially hurtful for families that are taking care of family members. It's just a wicked, wicked attempt to create another class of people that can't pull themselves up. And the message I got from the latest budget is we're going to have to not get sick and die real quick.
Thank you. Any other public comments?
Joe Kelly, excerpts from written discussion with CAO Boyce. CAO Boyce, can you provide me with information as to how the demolition and demolition costs of the old jail were included in the noticing of Measure J to the public? Also, how the demolition costs of the old jail was described or included in Resolution number 07-149, approved and signed July 31st, 2007 by the Calaveras County Board of Supervisors. Resolution number 07149 gives a statement basically to submitting to the public or the voters the bond issue. And it also goes on to show that Section 3, Government Accountability, the purpose of the bonds is to fund acquisition and construction of a new county jail, emergency operations 911 dispatch center, and support facilities. It doesn't say anything about demolition of the jail. B, the bonds proceeds shall be applied only for those purposes. Section 6, general authorization with respect to the bond election. All actions heretofore taken by the officers and agents of the county that are in conformity with the purposes and intent of this resolution are hereby ratified, confirmed, and approved in all aspects. Effective date, Section 7. On a motion by Supervisor Callaway, seconded by Supervisor Tryon, the foregoing resolution was passed and adopted by the Board of Supervisors of the County of Calaveras, State of California, the 31st day of July 2007 by the following vote. Ayes, 5-0. Bill Claudino signed. Karen Varney signed. She attested to it. There's an argument in favor of Measure J by the former Sheriff Downham promoting it. There's a statement that argument is true and correct. If that's true and correct, then something's wrong. Legal notice was given, notice of election, general election. The issue was notice given under 53410 and 5341. The county finds and directs that, A, the purpose of the bonds is to fund acquisition and construction of a new county jail, emergency operations 911 dispatch center, support facilities. The bond proceeds shall be applied only for those purposes. There's also a discussion of a bond proceeds account and that there will be an annual report. No discussion of demolition of the old jail. There's a 5340 is a statement indicating the specific purposes of the bond, specific purposes. A requirement that the proceeds, B is a requirement that the proceeds be applied only to the specific purposes identified to subdivision A. And there's another thing in there, but that doesn't go to that. It relates to the status of any project required or authorized be funded as identified in subdivision A of section 53410. So that is an important part. Calaveras County Adult Detention Facility Needs Assessment, March 11, 2008. TRG Consulting. In that states unresolved issues. 2 issues remain unsolved. These include, I'll go to the second one, that's the important one, the use of the existing jail once a new adult detention facility has been built. Part of the existing jail may serve as court holding until the courthouse is constructed. The other options under consideration for the future use of the existing jail include use for storage and use for county office space. Other options will be considered. Implementation strategy to resolve issues. The planning committee from the Sheriff's Department that oversaw the completion of this needs assessment, along with staff from the Judiciary, the Administrative Office, and the Board of Supervisors, will be responsible for the processes that will resolve these 2 issues. They plan to meet and continue to resolve these 2 issues over the next 6 months. At least now I know who did it. This unresolved issues was mentioned 2 times in that particular thing. Now we go to July 1st, 2008, final minutes. Agenda item 18, administration jail bonds. Shirley Ryan, administrative analyst, initiated a conversation regarding the issuance of a general obligation bond as authorized by Measure J. She introduced Jonathan Edwards of Government Financial Strategies, Inc. Mr. Edwards spoke of a bond issuance amount of $31 million. Supervisor Tryon stated the bond authorized the money to be spent for a jail, sheriff's administration, and dispatch center. He asked if all the money could be used for a new jail. Mr. Edwards referred to the intent of Measure J as including the 3 projects, although he did indicate that the entire amount could be used just for the jail. Tryon stated that it was represented to the citizenry that the county would receive a state match. Mr. Edwards stated the only requirements to issue bonds are that you spend the money on an authorized project. Chair Walensky expressed concern of keeping faith with the voters of the county and making sure that what is done is consistent with what they understood when voting.
15 seconds, Joe.
San Andreas, an agreement has been executed between the San Andreas Sanitary District and the county for sewer services to the project. One requirement of the agreement is the disconnection of the sewer service to the existing jail.
Time's up, Joe.
Thank you, sir.
Thank you. Any other public comments? If so, please come forward. Seeing none, that completes public comments. We will now recess from the Board of Supervisors and will reconstitute ourselves as the Air Pollution Control District Board of Directors to consider authorizing the Air Pollution Control Officer to administer the Carl Moyer program for fiscal years 2010 and 2011 through 2015 and 2016. This is being brought to us by the Environmental Management Agency. Brian?
Good morning. Brian Moss, Administrator of Environmental Management and Air Pollution Control Officer. As stated by Chair Tryon, staff is requesting approval of the attached resolution authorizing...
Brian,
yes,
they're having a sidebar.
I'm sorry.
Normally we don't.
No.
You have...
I can do it after Mr. Moss.
Okay, let's finish with Brian, and then I'll come back to you.
We're going to finish with you, Brian.
Go ahead.
Thank you, I think.
Since we're in the air condition.
Well, I have a problem with reconstituting it. Are we supposed to reconstitute ourselves at Air Pollution or reconvene ourselves?
Whichever you'd like.
I'm going to reconvene.
Staff is here today to request that the Air Pollution Control Board approve the resolution authorizing the Air Pollution Control Officer to apply for Carl Moyer grant fundings from the 2010-11 years through 2015-16. This is an application that actually comes before the Air Pollution Control Board annually. Checked with the Air Resources Board and asked if we could do one for a 5-year stint, and they thought that was a good idea. In light of the fact that we continue and plan on continuing to apply for these funds. Grant money can be used for the following purposes: on-road heavy-duty engine applications, off-road heavy-duty engine applications, agricultural engines, and forklift engine applications. This actually is an amount of $200,000 annually that is brought to the county. Funding is provided to the public sector and the private sector, whoever applies for diesel retrofit on their engines. We've been successful. We've distributed just a little over $475,000 in monies to help retrofit engines to come into compliance with new diesel emissions for 2010 engines. And there are varied dates for different types of engines to come into compliance. Any questions? Yes, sir.
If I have a member of the public who would like to utilize those funds, what's the process that I need to go through to help that individual?
First, I'd ask that they would contact me and contact our district. And then what we will tell them is to have their engine evaluated and get us a cost estimate for the retrofit of the engine. And then they will apply for the funds, and then we review that application along with the Air Resources Board in Sacramento for possible disbursement of monies for retrofit.
Steve.
Are you done, Darren?
Yeah.
I had a question about the, we have a 15 to 25% match in order to meet the state mandated economies of scale or economy of the program. What determines whether it's 15 or 25 or anything in between? Is there some formula? Or
there is no formula that I'm aware of. What that really is it's kind of the way it's stated in that cover letter. Right. Everybody's going to need to meet these requirements depending on the year of their engine. We're requesting a 15 to 25% share on their side so that we can get the funds to be distributed further out. In other words, so we can have more participants rather than 100% funding. If people have some say, instead of them purchasing or retrofitting at 100% cost, we can cover 75 to 80% of it. That helps them, but it also helps us to be able to extend those funds further out to the community.
And that's determined administratively?
Correct.
Based on individual circumstance, condition, year of
I would say yes. Yes. This is something that our previous air pollution control officer had come up with that formula. This is something I'll be looking at with the Air Resources Board and asking them as well for their input. But again, it's a matter of being able to extend those funds out.
Right. I agree with that wholeheartedly, that we try to extend it. I just want to make sure that we're doing so not so much on a whimsical basis, but
Agreed.
Based on specific criteria that all applicants would understand before application rather
Agreed.
than simply as a
yes.
whatever we think of.
No, I absolutely agree with that.
All right. Thank you.
Thank you.
I have another question.
Go ahead, Darren.
When I was reviewing the documents for this proposal, or the continuation of this, it seemed to be that the primary focus is reducing the amount of atmospheric, harm. I didn't see anything in there that specified that it had to be diesel retrofit. Could it be anything other than diesel? Could it be hybrid or battery, electric powered, any kind of stuff like that? Or is there something specific that just wasn't delineated in my board packet that's a little deeper about the requirement for diesel specifically?
This is diesel specific.
Okay.
So everything from tractors, off-road, and on-road buses and trucks, and depending on gross weight. So, and then depending on gross weight will depend on when these engines need to come into compliance. That's a requirement. That's already in motion from State Cal EPA Air Board. What we're trying to do is bring a few dollars back to the county to help individuals meet those criteria rather than just saying you must meet those criteria. But it is diesel, to answer your question.
Does it allow for diesel hybrid, or it has to be 100% diesel?
It would probably be 100% diesel in terms of the fact that we're trying to bring in upgrades of vehicles that are 2000 or 2005 or 1998, vehicles that are, let's say, tractor, trailer rigs, those kinds of things tend not to be hybrid. If that was something that came to us, I would contact ARB and ask them their input on funding options for that.
I'm specifically interested in a vehicle that Ford Motor is recently retrofitting from diesel to diesel hybrid and also straight electric that could function as a replacement for small transportation buses for public transportation, which I think would fall under that category. They have diesel hybrid, and electric, and that's something that could help with our situation. So that's my line of reasoning for the question. So.
I understand. Yes. Essentially, if somebody were to come to us and say they're going to retrofit their engine, for emissions is one issue, and that's what we commonly see. Mm-hmm. But if they say we're going to replace an engine and we want to replace it with a modified engine that is part diesel, part electric, that kind of thing, again, run that by the Air Board. Obviously, the goal of this program is to reduce emissions from diesel engines.
Thank you.
Thank you.
Any other board questions or comments? Public questions or comments?
On a general public comment, I asked to have a more open and transparent policy. I would love to know this gentleman tell me, when he said state fund, whose state fund is it? Right now, my impression is the state is broke. And I really appreciate all their concerns. Now, I complimented you folks because you had 40 committees that keep you busy. Does anybody know how many committees the state has? Give you an idea, over 500. And they all going to be fighting to exist, to keep their jobs. But knowing the financial situation of this state, they are looking for importance to stay surviving. But folks, let's get real. You ain't got the money. You don't have the money. The state don't have the money. The feds don't have money. And anytime you approve or support any kind of funding, you put it on your kids. I don't care about your brother, folks. Be blunt about it, okay? You keep your brother. But I'm worrying about my kids, my grandkids, and their credit card that all these good deeds going to be charged to. Because none of my elected officials in this county, in the state, or at the federal government has any money. Now, I appreciate the redistribution of the funds, but they want to redistribute funds that they do not have. And folks, I like to see my elected official in this county not be the problem, but the solution to the problem. Because up to now, all this attitude, and whatever righteous it is, you folks have not been the solution. You folks and your attitude been the problem. And yes, my supervisor, sir, I'm proud of you that you swore on the Bible, and you have my support. Thank you.
Thank you. Any other public comments?
Boy, I don't have a Bible to swear on, but it seems that this is AB 32 we're talking about, the new requirements. As I understand it, a large number of scientists are claiming that CO2 does not cause global warming. It follows global warming. Well, if that's true, then the scientific basis of AB 32 is false. AB 32 has requirements to reduce or restrict the amount of CO2 that goes in the atmosphere. If this is what this is all about, I think the taxpayers would like to know exactly, or as close approximate estimate as you can do, what the damage is going to be to the private sector that has to change their engines. And the point which was previously made, the state is broke, the federal government is broke. There can't be any money that would come to to pay for this from the government. And if they would be, it would have to be financed from our children. So what do? You have apparently a legal law. The state has passed a law that is unwise and destructive and perhaps even oppressive. What can the County Board of Supervisors do to try to protect the citizens, try to protect the taxpayers? Frankly, I don't know. But one possible approach would be the legal approach to raise these issues, or anything else you can think of doing that would protect the taxpayer and protect the citizens. To summarize, before approving this, please find out what the cost would be to the private sector as well as to the public sector. Thank you.
Other public comments?
Michael Wietrich. Good morning. I have a couple of questions based on what I'm hearing here this morning about this program. It's my understanding what was stated there is that this program was sold to us, the public, as proper use of funds to help people convert their engines to comply with the amount of pollution that they're putting out. So if that's the way it was sold to the public, and you guys entered into an agreement saying that the state was going to pay a certain percentage and you guys were going to make up the difference, how can you go back now after the program's implemented and tell the people, now all of a sudden we sold this to you, that we're going to convert this for you and pay for 100% of it, but now we changed our minds and now you need to pay 25 to 30% of it that a lot of them can't afford to do. So which one is it? Was the program designed to pay for the whole thing, or was it designed to pay for part of it? And if it was designed to only pay for 75% of it, it should have been sold to the people that way.
Any other public comments?
Yeah, I'm a little more from Valley Springs. And I grew up in a town that had a sewer creek. The sewers of this town flowed into the creek, and the creek flowed right into Lake Michigan. And when the state told them that they had to stop doing that, they all complained that they couldn't afford it. So you got a situation here of well poisoning. People are poisoning a public well for personal gain, and some people are complaining that they should be allowed to go on doing this because we can't afford to fix it. Thank you.
Joe Kelly, I guess it would be cost to the private sector would be they wouldn't be able to use their trucks if they aren't able, or they would have to buy brand new ones or buy one that has a 2010 registration on it to be able to continue in the state of California. Now, I do understand there might be some exceptions to this that are going on. This thing has been going on since the early 2000s. It started out on the diesel thing and with the ARB, a concern of people putting their nose up to the exhaust pipe of a bus all their life, 70 years, a cancer problem. Okay, when it was brought to the CARB and asked, well, tell us about this, how you determined this problem, a doctor who sat on the board did like a lot of officials do, I don't care. I want to see cancer stopped. My son and I started to walk out after a 5-hour trip. Well, I've watched this thing go on. I just talked to Mr. Moss earlier to find out some information. I'm going to talk to him a little more and get some more information. This is a $200,000 to this county, 5 years, $1 million. That's not going to cover the amount of trucks that are in this county. If this economy doesn't turn around for these people to go out and buy new ones, it probably won't account for a full retrofit with all the additional, and that goes from 100 to 125% of monies from the state for that, for the truck owner. So we have a problem here. There's also, I read a while back, that there's $14 million that per year that are allowed by the state through the CARB for this program, and we're getting $1 million in a 5-year period. it's hard to say what's right or wrong. I hear Mr. Race, I understand Mr. Race, but I also see we can have a heck of a lot of trucks parked, and we will have. And if you think the economy is bad then, wait till you see all these guys that haul fruit in the valley, and their fleet of 10, 12, 20 trucks are all parked because they can't go on the road. They can't relicense. My only hope is that there is going to be some exemptions because of the economy, and that it carries over to 2014 and gives those the ability that having, say, a 1990 truck and have paid for it but have not made really any money on it because of the expenses of it, that they will be able to recapture some profit off that vehicle to perhaps be able to assist in going forward with a retrofit or the purchase of a new 2014 or one that fits within the Tier 3 statutes, and probably at 2014 Tier 4 statutes. Thank you.
Thank you. Any other public comments? Seeing none, I'm closing public comments. I'll bring it back to staff. Brian, you have some additional comments for the
Just
board?
a couple comments. This is not, for Al, this is not AB 32. This is something, as Mr. Kelly just stated, has been going on for several years. This program has been going on for several years. There are going to be some delays in the requirements. As an example, if you have 3 or less fleet vehicles that you needed to come into compliance in 1/1/12, that's being delayed by CARB possibly to 1/1/14. So there are some things that are happening at the Air Board. From what I understand, they're pretty well aware of the concerns of some of the concerns that's been stated here this morning. The other issue is I will go ahead and contact ARB. Didn't have a chance to find out specifically where they get their funds, because they're the agency that distribute the funds, and I don't care to give you an answer that I think is the answer, but I'd rather confirm that, and I'd be happy to share that with you. Sir. Any other questions?
Yes. A quick question of Brian. It's my understanding that the Carl Moyer Fund mostly goes for public sector retrofitting. Is that correct?
It can go to either. It's open
Does
to
it not
both
mostly
public
go
and
to
private.
public sector, like in our county?
We have distributed funds to Public Works in the past. That is true for retrofit. But we've also, and the Calaveras Unified School District, but also, as an example, some other privates, Canby and some others that we've been able to distribute those funds for. The problem is it worth it? From a business standpoint, is it worth the retrofit and the cost? And that's, I think, the issue that a lot of people come up against when they come to us and say, yes, we can provide the money, but then they look at it and quite honestly, it doesn't make sense for them to upgrade an old engine. It's less expensive to go another route. So that's where we see some people say they're interested, and then as we go through the process, they realize that it's not as fiscally beneficial as they initially thought.
Gary?
Brian, can you explain, Mr. Wietrich had a question about the 75 versus the 100%.
Yes.
And can you explain that one more time?
Oh, absolutely. That has actually been in place all along, as long as we've been doing this program. The share from the private party, that's not something we're changing. That's something that we've always done as long as we've been doing the Carl Moyer program. But something that I will be doing is contacting ARB and double-checking with them as to what they're seeing as a general policy. Again, as stated to Supervisor Walensky, our idea is to be able to extend those funds further, but this is not a new share.
Okay, any other board comments or questions? Shane, Marita, Aaron? Okay, then I'll bring it back to the board. Chair is open for a motion.
I'll move this item.
I have a motion by Supervisor Callaway, a second by
I'll second that.
Supervisor Walensky. Do I have further board discussion? All in favor so indicate by stating aye. Aye. Opposed?
No.
It passes on a 4-1 vote of the board with Supervisor Spellman voting in the negative. We will now adjourn from the Air Pollution Control District. We will reconvene as the Board of Supervisors, and we will move forward. Does anybody need a break? Board all right?
I wanted to...
Oh, excuse me. Darren had a comment. He wanted to respond to one of the comments, I believe, under public comments. I'm sorry, Darren. Please, the floor is yours.
There was a couple of questions that came before the board that specifically have to deal with District 5, which I represent. And I think there were two people that brought questions, both Mr. John Raines, who I don't see him, but I see Alice, so I'm sure Alice can pass on to him what's said. And then Ms. Crane had some questions or comments. I'd like to ask Ms. Boyce to speak to Mrs. Crane's assertion that the county would not pay for the 5 days of my attendance at CSAC should I have chosen to stay there.
The policy has been that new supervisors attended the New Supervisor Institute, which is a 2-day event of a 5-day, the entire CSAC conference. It has been past practice that supervisors attend that and then can be reimbursed by the county out of the Board of Supervisors budget within your allocated travel and budget. So if you had in fact chose to attend the 5-day session, you could have paid, you would have paid for it out of pocket, and then once you had been sworn in January, you would have been able to be reimbursed for that expense.
So contrary to what Ms. Crane suggested, the county would have reimbursed me for the full 5 days if I had
out of your allocated amount of for your yearly budget. So if you chose to use that from your allocated amount, you could.
Did we, I thought we either cut severely or eliminated travel budgets for this year. Do you know where that stands?
You have limited travel budgets. It's in your Board of Supervisors budget. Madeline is here. I don't recall right off the top of my head what your individual amounts are, but all budgets have been cut severely. So,
yeah, I thought
for example, if I go on business, I don't charge the county. Yeah. I think we're all living within very limited budgets.
Thank you for clarification on that, which makes the point that I made previously that Ms. Crane made some ill-timed remarks about, and that was that I could be reimbursed for the full 5 days had I chosen to stay. I only chose to stay for the 2 days of the beginning supervisor instruction so as to save the county taxpayers' dollars that could have been spent for the remaining 5 days, which I chose not to stay. So I just wanted to make that clarification that Ms. Crane made an inaccurate comment in regards to those expenditures or my ability to expend public tax dollars. And so also on that note, it wasn't Chris Rock, it was Sinbad, the comedian, that was performing on Thursday. The next question or comment about in regards to using staff time to locate a Bible. The Bible was located by Lynn Epler, one of my committee chair people for my campaign, not county staff. So that was also an inaccurate comment made by Mrs. Crane at the microphone. The Bible was found by Miss Lynn Epler in the courtroom, and I also acquired one from a friend of mine who runs a business on St. Charles Street down the road. And so we actually had 2 Bibles in our possession at the time, but neither was found by county staff scurrying around the premises using taxpayers' dollars to find them, contrary to what Ms. Crane stated. So I just wanted to make sure that everybody was clear on those points. A wise former supervisor of Calaveras County, Paul Stein, told me that a lie left on the table becomes truth if not addressed. So, in that light, I wanted to make clarifications that these things were in fact truthful statements that I made originally, and the statements that Ms. Crane made in opposition to that were absolutely false. Next on the list, Mr. Raines had questions about CSA versus CSD conversion for Rancho Calaveras. And he also made a statement regarding an attempt to try to use county staff to do the paving of CSA 1 roads if possible. There has been some questions about conversion from CSA to CSD in the Rancho Calaveras area. This conversation is a direct result of members of the public who came to me as a candidate during the campaign saying that they wanted to know what, if any, recourse they had for different ways of carrying out how the money is expended for the road servicing and other things that take place in Rancho Calaveras, CSA 1 area. I did research. I also spoke with County Council extensively, including Mr. Sirius, Mr. David Sirius, who's an expert on 218 and CSA matters. And I reported back to the RCPOA board, and since that, the information has disseminated into the community, which is that we could convert. When I say we, I'm a tax-paying citizen who lives in that community, so it would require a 2/3 vote of the people who live in that area to do any conversion. And whether it was converted or not, it's only an option. People wanted to know what their options were. Conversion from CSA to CSD is an option. It would only be taking place if 2/3 of the people were in agreement that they wanted to make that conversion, and that would have to take place on a legal ballot during the election process. So we can talk about the differences between a CSA and a CSD at a later date, perhaps, if you'd like to visit me on a Thursday afternoon at Rancho when I hold my meet and greet sessions each Thursday at noon at the clubhouse. And I'd be glad to talk to you about the differences between those two potential management facilities. The other thing was, in terms of road paving, it's been made known to me that they have tried to use county as much as possible in the past to try to keep some of the county staff employed and perhaps use some cost-saving measures if the county's already out doing paving. And I have no problem with that if the price that's being paid is commensurate with the going rate. I would prefer to use somebody that's a contractor in county if possible. And I would voice that opinion to the Board of Supervisors as a governing board for the CSA1. However, I believe that this board, including myself, has a fiduciary responsibility to the ratepayers in CSA1 to obtain the best rate possible. So if it is that the county can provide a rate that is at least near or equal to the going rate that we could obtain from a private contractor in the county, then I don't think it's a problem for public works to do the paving. However, if we find that the paving costs are extremely inordinate or out of line with the going rate, I don't see that we could do that and still say that we're maintaining our fiduciary responsibility to the tax-paying citizens to get the best bang for the buck for those people. So, thank you.
Your comments. Any other board comments? Seeing none, we'll move forward to item 7, board discussion and direction pertaining to changing the Board of Supervisors agenda format. This has been brought to us by administration and county council. It's a continued item from approximately a week or 2 weeks ago. 2 weeks ago. So I'll go to Jeannie first, and then Jim. Do you guys have any additional comments at this point?
No, we do not.
You stand by the recommendation?
Yes, we do.
Jim, same for both of you. Okay, then I'll open it up for board discussion, see if there are any comments before I open it for public discussion. Board have comments at this time, or should we do public discussion first? Public? Okay, I'll open it for public discussion. Are there any public members of the public here present this morning that wish to address the board on item number 7, which pertains to something I have in here. Board of Supervisors agenda recommended changes. These recommendations have come from County Council and the Administrative Office. Change total time allotted for public comments to 15 minutes per meeting. However, give the board discretion, subject to approval of the chair, to take additional public comments beyond the 15-minute period at the end of the board's agenda. So in other words, the public comments at the beginning of the agenda of the regular agenda would be limited to 15 minutes. Any public comments thereafter would come at the end of the board's agenda. And secondly, to change the allotted time per person from 5 minutes per person to 3 minutes per person and 15 minutes per topic. And thus the time limit is waived, subject to approval by the board or the chair. So that's what's before us. If there are any public comments, please come forward at this time.
Can I ask a question?
Yeah, Alice, stand up, will you?
She has to come up.
I wanted to find out, what was that first part about 15 minutes, and then you come at the end 15 minutes per topic? Could you explain that?
Well, that means, like where it says public comments on the board's agenda, that will be limited to 15 minutes. And when 15 minutes is up, it stops, and any other additional public comments will come at the end of the board agenda. Okay, if you have any other comments, you need to come up. That's just a clarification of what's before the board.
Good morning, Supervisors. My name is Laura Most, and I live in Rancho Calaveras. I love America. Our military men and women are fighting on foreign grounds for one of our freedoms that you are asking us to give up today, our freedom of speech. Supervisor Spellman, you taught history at Calaveras High School to many of the young people who are putting themselves in harm's way to protect our country. I came to the board this morning asking you to leave the public comments as they are at 9:10 and allow each person to speak up to 5 minutes for our concerns. Many of us have jobs and it's inconvenient to be gone any longer than that. In Tracy, to discourage us from speaking, the City Council put public comments at the end of the agenda. Many nights a group of us were speaking to an empty room, the City Council, and staff at midnight. Many members of my family have fought on foreign soil for our freedom. In World War II, I had 6 uncles who were overseas. As a child, I remember one uncle lying in a bedroom for several months with his eyes bandaged, not knowing if he'd ever see again. Thank God he did regain his eyesight, but he walked with a limp as he escaped a burning Navy carrier. My brother served in the Army. My brother-in-law served 19 and a half years serving our country as a Navy pilot. He was on 3 6-month deployments away from his young family. He also served on the U.S. Carl Vinson for 2 years. He passed away in 2004 at 44 years old, leaving his wife, my daughter, and 3 of my grandchildren aged 17, 14, and 12. The military deemed his death as military-related. My favorite uncle tells the story of how a Filipino family pulled him and 2 buddies out of a burning airplane and took them to their home. He and his buddies lived under that home for several months until World War II ended. They looked through the little windows in the basement where they stayed and could see the Japanese soldiers marching with their guns. They knew what would happen to all of them should the soldiers discover their whereabouts. I have great respect for that Filipino family who risked their lives to save 3 American soldiers, one being my uncle, who lived to be 76 years old. I am requesting that you do not take away our rights of freedom of speech or discourage us from our freedom of speech. In front of the little Constitution booklet, it's Only Keepers the People by George Washington. Thank you.
Thank you. For the record, we'll limit public comments on this item to 4 minutes per person, okay, so we can get through it. I think there's going to be a lot of public comment.
Good morning, Rosemary Wilson from McCallum Hill. I was not at the previous meeting where apparently you had discussed changes to the agenda, but when I look at the agenda format, a couple of things that come to mind in addition to the public comment, and I'd like to suggest a couple of things or comment on a couple of things. I do like the format in which you conducted the public comments this morning, Tom, because you allowed those people from various departments to speak first, hence enabling them to return to their duties at their respective departments and not sit for a lengthy time. I know there have been occasions, specifically with behavioral health services, where an item was to be presented and that impacted a number of people in the department itself, and then essentially the whole of the department I know Rita Downs might question that, but it seemed like the whole of the department had shown up, and it was 45 minutes into the public comments that the particular item was raised. One thing I would like to comment on would be in terms of the agenda, would be the specifying the dollar amounts that were to be approved, considered for approval for the various items under discussion on the agenda. It appears to me that when CalWorks, in particular, I remember standing and addressing the board, that they have tended to specify the dollar amount essentially not just to the dollar but to the cent. And that makes it easy for those of us who like to attend the board meetings but do not have the inclination to sift through the packets that are available for review prior to the meetings to really get an idea of the dollar amount. One particular instance that I found that I still remember, although I don't recall the precise wording, was just before Jeannie was to be appointed as the CAO, and I'm delighted that Jeannie is here and her staff is working for us too. It did, however, seem to me that the wording setting forth the budget in terms of the county administrative office salary apparent changes were stated in human resources jargon that did not even, that the typical person may not have understood, that we were talking in terms of 250,000 or so in that one item. So I would like to see the dollar amounts in the specific agenda items where possible. Thank you.
When you come forward, it would be appreciated if you keep your comments to the agenda item before us, which is the public comments issue. Thank you.
I appreciate the work Jeannie's doing on this. And I don't think the reason for limiting the time is so much to do with the random people that talk, including me. I think it has more to do with organized efforts to persuade the Board of Supervisors on some issue, one way or the other. And I think that our present system of 5 minutes, or as the board chairman rules, has been working all along. And there are times where the taxpayers and the public have things of real concern, because what you do affects their freedom and their money. So there's no great public purpose that's served by statute, reducing the time that they can address the board. There are some rules that you could do that would allow the process to work better, and I think the board chairman can think of those, such as when looks like there's a controversial issue, have a raising of hands of the people that are for or against that particular issue. Then it may be 1 minute per person, or it may be 3 minutes. But the important thing is to allow the public to speak in a reasonable manner. To require that they wait to the end of the Board of Supervisors meeting, which a lot of times we don't know when that will be, before they can speak, is not reasonable. because the people that are talking here, including me, have to earn a living. They can't sit here through the whole Board of Supervisors meeting to wait until it might end so that they can make their comments. So I'd recommend no change. What you have is works, and thank you.
Thank you.
You got a fan club there, it sounds like, Al.
Michael Wietrich. I could be confused, but I'm under the understanding that, my time is important too. I'm a local business owner, and I'm losing money by being here today to speak to you guys. I lose money every time I come here, but I come here because there's things that are happening in my life that you guys are in charge of that are important to me. And for me to not have the right to address you in public, that's what this meeting is for. That's why it's a public meeting, so that everybody can see what's going on. That's why they're open to the public, so everyone that's watching that tape or that's sitting in this room knows what's going on here. And for our rights to be limited, there's things sometimes that don't require us being here and voicing our opinion. But those of us who pay taxes are paying your salaries to sit there and listen to us and do our business because we can't be here to do it. And for our rights to be limited, there's many times when I've sat in this chamber and the 5 minutes has been used on many people. It's been used on myself. You use your 5 minutes, and there's things that happen that it takes 5 minutes to try to relay even half the points that you want to address during those 5 minutes. If you limit that to 3, that means that I, as a business owner, am not out there making money and paying taxes to support your salary. And I've got to sit here and waste my entire day to wait till the end of the meeting to be able to voice my opinion that I should be able to voice at the beginning of the meeting. It's also been brought to my attention that, one of the reasons for this was the waste of administrative time within the county because they're standing around this chamber while there's something on the agenda that they're waiting for. This meeting is being broadcast through this entire facility right now. There's no reason for them to stand here and waste time while they're waiting for an agenda item to come up. If they're listening to that thing, all they have to do is say, oh, they're on number 5, we're number 6, now we need to go over there. So that excuse that, we're wasting their time, that doesn't fly because they all know what's going on in here right now. So the only thing I can see is the reason that they don't want us up here commenting is because it's a problem for you guys because everyone knows what's going on. And, if there's nothing being hidden here and there's nothing being done that you don't want the public to know about, then we should be given the right to have 5 minutes to state what we want to talk about. And it says right in here, it's under the discretion of the board chair. And I believe that if the board chair is doing their job properly, they have the meeting under control. And if there's an item that there's 20 people in here and they all want to have their 5 minutes to speak on it, it's obviously something that should be put on the agenda because it's very important to the constituents of a certain area. So, it's a matter of the chairperson taking charge of the meeting and saying, well, based on the amount of comments we have here, this is obviously something that needs to be agendized so that everybody can come back here, know when it's going to be on the agenda, and have our right to speak our piece and to ask our supervisor to do what we would like them to do in that manner. But to be silenced and for me, as a taxpayer and as a business owner, to be asked to sit here all day and wait till the end before I can have my say on something, I don't believe that's right at all.
Mickey Parks from Rancho Calaveras, and it's on the item that we're talking about. Proposed setting stricter time limits for the public to speak to the board. Supervisors during public comments on any subject is biting the hands that has elected you, and it's restricting public participation. You are elected to listen to our constituency, not make it increasingly more difficult for them to present their issue. County employees need time and have to wait for the public comment to present their issue to the Board of Supervisors. This issue is easily solved by scheduling a county employee comment time, either before or after public comment.
scheduled time. Public comment is for the public and should be separated from the business of the county employees. It is my understanding that there are speakers in a number of county office and county employees can hear and monitor the proceedings of the Board of Supervisors meeting. It is not necessary that they wait in the audience. Setting more restrictive time limits for public comment is not the answer. It will limit public trust, it will limit freedom of speech, and discourage public participation. If an issue is important, there should be circumstances that allow an extension of public comment time at the discretion of the chairman. An example of current issues that may need more adequate public comment time before the Board of Supervisors would be the subjects of community plans, the general plans, and the U-Plan. The U-Plan model was not shared with the public in regard to the development of community plans. It would be a miracle if any of the current or proposed community plans pass the U-Plan test. This will be a public issue of controversy, concern, and public comment in the near future. It would not be appropriate to limit public comments or public participation at this point. The public needs to be respected. The current time of 5 minutes per person and 15 minutes per subject is barely adequate and should not be changed. Thank you.
Thank you.
What number you have? My name is Peter Reyes, Valley Spring, and I'd like to disagree with some of the previous speakers. As far as limiting or maintaining, I like to have it increased, folks. I like to see your butts down here some evenings. At our convenience, not your convenience. It's very nice to have it middle of the week, middle of the day, and I know it's very convenient, but for your sake, I give you sympathy. I've been on both sides, and what you got here is one of the best safety valve you can have. Because for some people, it's very hard to come up and talk. For some people, it takes a big effort. They don't like to come up and talk. I enjoy it. I could talk for hours. And I control myself not to go into rebuttal for some of the comments that's being made. I'm well behaved.
Is that an editorial comment?
And I control myself not to make you folks feel, well, how put this, like, foolish with some of your comments. There's 3 of you up for election, folks. And if you think you can muzzle, well, let's muzzle me. Get a reality check, folks. Nowadays, the kind of communications we have, what you say, 5 minutes later, I have 10 comments on my email. Seconds later, I get comments on my Facebook. And I will express my opinion. And in the future, you're going to get some surprise because there's going to be more ways to express opinion. This is a good defense. You have a chance to reply. You got staff around. All it takes is make you a phone call. And the head of your department can be here, give you good advice. But in the future, when you're going to be talking in public, you're going to be on the same level as everybody else. It's going to make it very uncomfortable. Those of you who want to get reelected, unless you have an application to Africa or something, get a job. But folks, my suggestion, increase it. That's for your benefit also. You're going to be aware for somebody to come down here and spend 3-4 hours. And most of the time they feel just the same way you do. It's more boring, repetitious, ignorant, and all that stuff. And I can understand your feeling. But the same people are going to sit here through the same comments and feel the same way about what you guys are saying. And it's a good way to let them express themselves so you're aware of it. It's for your benefit. And I don't want to compare to what time, how much time you spend on other places, on other issues at Taxpayers Fund. I mean, you have time for 40 committees, spend time on the public expenses. But you have limited time to listen to us poor folks over here expressing their opinion. You have 40 committees. I saw the puzzling you look, sir, and I'm not going to punch you out. But there's 40 committees out there that you have time to spend time with. So please, grace us what your presence and knowledge, and share it with us so we can appreciate you more. Thank you.
Good morning, Alice Rain, Rancho. One of the things I wanted to bring up, in fact, most everything has been covered here, but for 30 years I've been coming to these meetings, and that's a lot of years to spend, really and truly, it's a lot of years coming up here and listening to the people with their complaints, with their problems, with their joys, their happinesses, and having the board sit there and listen. And all of a sudden, now after 30 years, you want to change something that has established your group as Board of Supervisors as one of the best for listening to the public. I've been to the ones in Stockton, I've been to Modesto, I've been to Sacramento, and they're cold. They're very cold people. They may be very nice personally, but they're cold. And they give the impression to the public, well, we are who we are, and we really don't take the time or interest to listen to you, but go ahead. But that's not the impression that you people have given us. We know that you're listening to us, and we appreciate it. But to change the time, to change the whole makeup of this is not good. You're doing it in a time when people call it a recession. I call it a depression. There is no money. People are losing their homes. They're losing their jobs. There's no place to go. They come here, they have a problem, they can't solve it. Maybe financially, maybe mentally. But you people sit there, and you have the capability of listening to us. And as Peter has mentioned, all the different areas, and as Mr. Wietrick and Carol, they've all mentioned subject, but the most important thing is that we have an opportunity to come to you as individuals with our problems. And we're looking to you to listen to us, to maybe offer some help. Take, what? Well, I won't put names out there. But there's a gentleman that's been coming for a very, very long time. I would like to see each of you whose people come from the different districts that you represent, get in touch with them, call and find out what you can do, who you can suggest they contact to get the problem solved. And then we have people coming up here praising you. Well, everybody likes praise. They go on and on and on. And all of these subjects coming up about what's in the future, those are important too, all of that. But the big thing is to change the time and take away our freedom of speech, basically, because most people talk for 5 minutes, they could go on for 10. A long time ago, they did have where you could say, point of order, and stand up, and I'll donate 3 minutes of the time of my 5 minutes. And that was acceptable. Now, that may help in cutting back on some of the comments from some of the public. But don't cut us away. Don't put us late at night like the school district has done. We had a big problem with the buses and school children being dropped off in the snow a mile from the home and any homes. What does the school district do? When I was on the Jenny Lind Fire Board, the two of us went up there, and we were hazmat officers, went up there and tried to talk them into the fact they got to keep those buses going. No, no, no. But they waited till midnight, and then we got to speak. What happened is they bought computers for all of the teachers. They spent the money on computers rather than the safety of children. There are a lot of things going on in this county we need to know about. And you bring the subjects up, but don't cut us off at the beginning, please. Don't make the time any shorter. But you can say, your time is up, or you get 3 minutes, and my time is up, and I thank you very much.
Good to see you.
I'm Will Moore from Valley Springs, and I sympathize with you members of the board having to sit through a lot of stuff that is sometimes not, very relevant. But I kind of object to limiting the opportunity for public input on a sort of general basis. I see it as a kind of an attempt to corporatize the county administration. And I think the basic issue is efficiency versus democracy. A corporate board is more efficient than a public board, but this isn't a corporation. A dictatorship is more efficient than a democracy. A military junta is more efficient than a democracy. So, like I say, I can sympathize with your point, but, democracy isn't necessarily supposed to be efficient. It's supposed to be democratic. Thank you.
Any other public comments?
Good morning. It still is morning. Feels like the afternoon already. Colleen Platt, myvalleysprings.com. As you know, we support public participation in local government. A couple of points. I wasn't going to mention these, but just in the comments that came earlier. As far as I'm understanding, this is not a continued item. This was not on the agenda before. It was only came up during correspondence during a board meeting 2 weeks ago. It was not on the agenda. It just came up during correspondence. There was a long discussion, which I listened to, and actually there was a suggestion at that time that the board just pass it, that it wasn't required to come to the agenda. And I want to thank the 3 supervisors that kept it from passing at that moment with no public input. Mr. Tofinelli, thank you. Mr. Walensky and Maria Calloway kept this from passing with no public discussion at all, so I'm glad this is on the agenda now. I also am a little concerned that there was an arbitrary limit of 4 minutes put on discussion here. That was something that hasn't been talked about before. What I came to talk about was that I am not in favor of the 15-minute total limit per meeting. In the county survey attached to the board packet, which we read, 13 of the 22 counties surveyed have no total time limit on public input. And I don't see why we should join the few that do. 15 minutes is not enough time for total public comment for the meetings for Calaveras County. I've researched the last 3 months of Board of Supervisor meetings and the length of public comment. The public comments are typically about 30 minutes long, and they're typically about 9 speakers. The range is from 23 minutes to 48 minutes, and from 6 to 14 speakers. And something that I think people are forgetting is that the consent agenda items also take up a lot of time in discussion, and sometimes people think that's all been public comment, and that's actually been consent agenda items. For example, today was 20 minutes of consent agenda item discussion. And then at another time there was further discussions, and sometimes that all gets lumped into public comments, which it's really not. And also supervisors engage in public comments. And watching the last 3 months, I don't know whether this is appropriate or not, but they have. Supervisors have engaged during public comments. There's been question and answers and discussions, and that's also gotten lumped into public comments. So if you start limiting public comments, you better limit the supervisor participation in public comments. I also support that Calaveras County has had a tradition of open public comments, and I'd just like to see that tradition continued, as many of the public has stated here. Some may call this belly aching, but others call it free speech, and I think this should be continued. We should be cautious in being overly restrictive of this free speech of the people. Secondly, I do want to, one other point is if you do set a 15-minute per topic limit, and you also set a 15-minute total meeting limit, you're setting up the situation that you could have 5 people come to the microphone, take up one topic, and that's the end of public discussion for the rest of the day. So I think that's not, again, the limiting to 15 minutes is not a great idea. We are also not in favor of having the comments at the end of the meeting, or having it at the beginning and then continuing to the end of the meeting. Again, looking at the survey of counties across the state, 18 of the 22 counties have public comments at the beginning of the meeting. So I don't see why we should join a group that does have it at the end. There's no support for that here. Only 2 of the counties had it at the end, and 1 had it at the beginning and continued to the end. And that way you effectively silence people who can't stay for the full 2 to 5 hours of the public meetings. So in summary, we support keeping public comments at the beginning of the meetings. We don't support limiting the total time of public comments. We prefer to keep that open-ended as the public needs to speak. And as far as to limiting it to 3 to 5 minutes per person or 15 minutes per topic, that would be at the discretion of the board, I would think. Thank you.
Thank you.
Marty Crane, Valley Springs, Rancho. First, I'd like to say that if I am ever inaccurate in something, and I did try to research this in admin and clerk's office, if I'm ever inaccurate on something, I would like to apologize. Okay? But that was just a little tiny piece of what I had to say this morning, so the rest stands. But I'd also like to thank Steve, Marita, and Gary for allowing this to come forward for public discussion. I'd like to say that aside from Mr. Race, I'm sorry I couldn't follow your conversation this morning. Okay. I have to say that I think I agree with everything anyone has said here this morning, beginning with Mr. Whitrick when I walked in the door and went, oh. So I think we have found commonality here. We do pay your salary. I think if we keep talking, we always can find areas of commonality and move forward in pathways to solutions. So, considering that everyone seems to be of the same mind out here, it seems to me that so far, if we make any changes, then perhaps we've glossed over and we are just talking to a brick wall. That's all I had to say.
Thank you. Any other? Any other public comments?
Joe Kelly, quite a well-spoken group that's been here on this issue. I have a concern, this 22-county survey, what is the public consent history of those surveyed counties? It didn't really give that as to history from some point previous to now. Where have they changed their times and what have they reverted to? And then what happened to the other 36 counties in the state? There's 58, I believe. 58 counties?
Yes.
52. I mean 58.
58.
58.
Thank you. What happened to them? This is kind of a unique thing. Public comment, as I've seen and witnessed in the past, in one county, changed all over the place. It went to the last point before the board went to noon recess. They came back. They couldn't digest their food after that. It bothered them. So they moved it even farther out. For over 10 years or better, it's been 9 o'clock. It has not changed again. They may limit the time. That's fine. But they didn't change it from 9 o'clock. A question that Supervisor Tryon brought up in his discussion the other day, how soon before this county will have applicants with their attorney, surveyor, or consultants filling this chamber? I think this is premature. I think I see everyone out here is pretty much citizens and not necessarily other than a couple of people that are department heads sitting back there waiting for the next agenda item. But I think there's citizens sitting here now. I don't think there's real big business going on right now in this arena. Something that was public comment, as I have also witnessed, and a judge asked me one time at a small claims court hearing, Mr. Kelly, are you the same Mr. Kelly I hear on public comment at the Board of Supervisors? And you can imagine what my thought was. Oh, and I thought, okay, yes, Your Honor, I am. I hope you find it entertaining and educational. I won my case. Thank you.
Other public comments, please.
My name is Don. That's Nod spelled backwards, D-O-N, Posland, P-O-W-L-E-S-L-A-N-D. I'm from Rancho Calaveras, and what I hear from all the public comment today is if it ain't broke, don't fix it. Thank you.
Any other public comments?
Good morning. I'm Tanya Dowson from Valley Springs. And I wanted to say I think it's a good idea to put the staff comments first at the beginning and let them get back to work. That sounds very efficient. But I would like to say that I think it's the way that the comments have been very good. I think 5 minutes per person is just barely sufficient, and 15 minutes per topic is completely insufficient. I don't think that should have a limit. And then changing the public comments, putting them at the end, that'll discourage people from commenting because the end of the meeting is so unpredictable. You never know when it's going to be, and for people to keep their schedules, and especially in this economy, it's important for people to be able to work and be more involved in that and dedicate their time to their jobs and their lives. And when the board is, when the public comments are toward the beginning, it's more predictable for the people. They can arrange their schedules much easier, and they can get back to doing the things they need to do. Thank you.
Thank you. Other public comments? Seeing none, I'm going to close the public comments on public comments, which was longer today. And I'll bring it back to the board for discussion. Okay, we had a discussion, 2 weeks ago, and then we gave direction, as I think Penny pointed out, to agendize it and bring it back today. So I'll just open it for board comments. Are there any board comments?
Well, I guess I'll start.
You want to start? Okay.
As I stated a couple weeks ago, I'm in favor of keeping it the way it is. I think the chair has discretion, and they can always let, who is ever chair can let the staff go first if there's staff out in the audience. We certainly know who our staff is, and we can bring them forward like you did today, Tom. I'm not in favor of limiting it to 15 minutes per topic. If you do, if it's a situation where there's one side and another side, it could be stacked with 5 people if it's 3 minutes per 3 minutes per person, or 5 minutes per person. And they could either have 3 or 5 people up there in line, and the other side has no way of saying anything, the opposing view of it. I also think if we do limit it to 15 minutes and then we put it to the end of the meeting, the same situation could occur. One side could have the whole audience here, and the other side could not speak until the very end of the meeting, when there's nobody here, and a lot of people could leave. A lot of times we sit here during correspondence, and there's absolutely nobody out there. It's just us sitting here. Also, if you limit it to 15-minute public comment period, staff could take the whole 15 minutes if you let staff go first. And a lot of times, some of the items that staff has brought forward, it takes 15 minutes. So I'm not in favor of that. I'm in favor of just keeping the way we are. I think chair has discretion. Chair can limit at the beginning if the room is full. I think someone brought up the fact that they could ask a question and people could raise their hands on why they're here to speak. Whether it's a community plan subject, which has filled this boardroom during public comments period more than one time. And I think we need to let the public have their say. I'm in favor of it. A lot of times I enjoy sitting here and hearing people speak their mind and what they have to say. So I think it's very important that we don't change it, and I would like to see it stay the way it is. chair has always had discretion. So those are my comments.
Other board comments? Aaron, you want me to go? You want to go, Steve?
Nope, I defer to
Okay.
the new
He's
supervisor.
deferring to me. I was
Okay.
deferring to him since he's senior. I'm the newbie, so.
I'm deferring to youth.
Okay. Okay. All right.
Go ahead, Darren.
All right.
He's got gray hair.
Yeah, I'm developing grays. I've seen in the mirror just in the 3 weeks, so we'll see. I appreciate those who come forward and give their comments during public address to the board, and I actually look forward to hearing those things, and I want to make certain that people know where I'm coming from and my standpoint on this. Any comments that were made a couple weeks regarding this subject, if there was any amount of sway, in my opinion, or ideas on the subject, it had primarily to do with inefficient use of staff time. If staff was to be located in the audience for an hour or so waiting for their turn on the microphone. But since that time, it's been made known to me that staff here within the government center all have the ability to listen to the proceedings and can be called at any given time to come to the mic and address their subject, which would not require them to actually sit here for hours. So they can be called at any time. So that negates any concern that I had regarding whether or not people had to sit here on paid county staff time. So with that objectional element out of the way in regards to staff sitting here for undue amount of time on our tax dollars, then I would be very much in favor of leaving it alone. And I think that the people that have spoken here today are representative of what constituents want in the county. We've heard testimony from people on both sides of the spectrum that are usually on opposite sides of the spectrum, that both advocating for their ability to come and speak to the board. I would also like to comment to Mr. Wietrich's question or comment in regards to him being here and losing money. I know that he is a private practitioner of a business, and I'm most certain that he's absolutely truthful in that when he makes appearances here, he loses or stands to lose revenue from his business that he's not attending to, which generates income for him and his family. And I'm sorry for that, and I appreciate his diligence and community orientation to be here to be a part of this process. I don't think Mr. Wietrich was here 3 weeks ago when we had a testimony given by a man named James Passote from Mountain Ranch in Mr. Walensky's district, who said he was a resident of Mountain Ranch for 27 years, and as a public school teacher is not able to approach the board at 9 a.m. on Tuesday mornings because he's teaching. And he asked at that time if the board would consider having at least one meeting in the evening where people who work 9 to 5 could attend. And I would submit to Mr. Wietrich also that in light of his comments today, of him having an actual loss at times to attend at 9 a.m. on Tuesday mornings, I would remind you that even though you're not in my district, I made a public press release during my campaign that I would advocate for some form of night meetings for people to be able to attend in the evening so as to not lose money from their business or have to take time off work to address the board. Supervisor Bailey, prior supervisor, with the help of Ms. Calloway and I believe Supervisor Walensky or others at that time, was able to get night meetings at least once a month. And I think in terms of Mr. Passote's comments 3 weeks ago in regards to the citizenry to have access to their local government, I would be in favor of that, and I hope that you continue to pursue that conversation with others in the community. Remember also that I come from an educational background where principals of schools, superintendents of schools, and others who are highly paid professionals are required to sit in school board meetings until late at night sometimes, and back to school nights, other various occasions that require them to be there, regardless of where they're at in terms of their stature on the the pay scale. So if it is that we need to have staff here in the evenings at some time to make sure that the public has access to their government, I would be in full support of that, including the comments that were made today about leaving this particular thing alone. Thank you.
Other public comments?
You mean board comments?
Board comments, excuse me.
But I guess we're public too, huh, China? Okay, I'll go. The exciting part of public comments is public comments. And you never know what's going to happen at public comments till it happens. And a couple of people got up today and said, well, I wasn't going to speak, but. So the chair can say how many of you are going to speak at public comments, and 4 of you raise your hand. And so chair says that's going to be 5 minutes. And then all of a sudden, you have 8 or 9 more people speaking because it triggers thoughts. That's the exciting part of public comments. That being said, there's also a huge agenda of business on behalf of the county that needs to be taken care of. And yes, their departments can listen to the board meeting and say, well, public comments are on, and I'm the next item, and I'll go sit. And then they sit for half an hour, 45 minutes, or you never know how long public comments are going to take. I do support a restriction of public comment time. 15 minutes is not enough. I am not sure who said it was on the average of, maybe Colleen, of 30 minutes on the average. I mean, I was thinking more on the order of 40 minutes, i.e. public comments start at 9:10 for the most part, and you can start your first agendized item at 9:45 instead of 9:30. I agree that it should not be at the end of the meeting. It agitates people. The end of the meeting can vary from 11 o'clock to 2 o'clock in the afternoon. And sometimes we'll take a break if it's appropriate and say we're going to come back at 1:30. And so then people who want to talk are coming back. I don't think it's a good mix. I think in terms of the time, it's not just the time for public comments, I think should be 3 minutes. If someone feels that they have to have more time, they can ask the chair for more time. The chair gives it. I don't think it has to be a vote of the board. That's up to the chair to manage the meeting. I like the idea of having, just before public comment, staff comment time. So if staff, like Krista had something she wanted to say today, staff can talk about something they want to bring up. If staff can let the CAO know it's just not an agenda item, it's just something they want to share, they can let the CAO know when they prepare the agenda. They can maybe massage the time a little bit. But normally staff comments are not very long, and many meetings go by where we do not have staff comments at all during the public comment time. So I think it should be starting 9:10. Staff time, the next agenda item starts at 9:45. And I don't really support 15 minutes per topic. You know, if everybody wants to get up and talk about one topic, that's fine. But I do think we need to have some structure to the public comment time, and just in terms of doing the business of the county. Thank you.
Steve?
I think we have a number of issues that need to be addressed under this general discussion. And for me, a couple of the big ones haven't really been brought forward yet. One of our problems when people say if it's not broke, don't fix it, is not the inconvenience to staff or the inefficiencies of government, but actually the people who had their issues on an agenda, for instance, those that are right now sitting waiting for a 10:45 session, are sitting here having had a kind of evolution that winds up with their desire to participate possibly threatened by the delays. And I've seen groups of as many as 40 or 50 wait. In fact, there was a day when we had 100 people waiting over in another building while we, after having had lengthy comments and plenty of repetition, managed to inconvenience 100 citizens who wish to express their free speech rights on an issue important to them. So I've been agonizing over this because I do believe that, as our first speaker mentioned, that the right to free speech, and in my view, limitations on that are very rare and generally recommended by the Supreme Court as hollering fire in a crowded theater, and anything short of that, whether we like to hear it or not, is something that we as a people have always stood for. So I have a real problem with limiting the time on a topic. I have a problem limiting time for public comment. I do, however, wish to find some structure that allows the comments of people who have an item on the agenda, staff, but mostly members of the public, to have some understanding that the time that we print in our agenda has some vague attachment to reality. And I think we're really stumbling on this. And for me, maybe there are, and nobody's spoken to this, but if we're in fact averaging 30 minutes, which is easy enough to find out apparently, maybe we should not be scheduling anything else until later. Another aspect that's come up, and I believe it, is that I don't believe our staff should be using public comment time to make their announcements. And I think there are two ways we can deal with that. One is they could join the board on that matters of correspondence and just join us in that aspect and not get in the way of the public discourse that's been so well articulated here today. Another set of issues, and the biggest one to me, is that it may be that we're seeing the same faces over and over again, but we're also holding public comment at the same time over and over again. And people's work schedule, and what worries me is that we're taking working people and leaving them entirely out of the dialogue, unless they wish to make a sacrifice, as Mr. Wietrich is doing, or if they want to call in sick fraudulently or somehow rearrange their schedules. But I don't believe that mitigates toward the kind of diversity of comment and broad outreach that governments need to be able to hear in order to make good policy decisions. With that in mind, and although I've been saying this for 6 years, I'll say it again. I believe there's a second in the room at this point on the idea of once in a while at least holding meetings at other times where a different shift might show up. We see the night shift maybe here, maybe even the swing shift on occasions. But the day shift is pretty much disenfranchised for the most part, while retirees have a greater participation potential. So let's mix it up a bit. Let's give these meetings an opportunity to give people working other schedules an opportunity to speak to this board by scheduling occasionally at least an evening meeting, maybe trying it out and seeing whether whether that does increase participation. That said, if we needed to have some form of compromise to reach an agreement relating to this set of proposals, I would think that a 9:10 start to public comment, a 30-minute section, so that or whatever the next scheduled thing can actually begin somewhere on time, and a chair's discretion as to whether it's 3, 4, or 5 minutes, having some idea of the number of people who wish to speak, allowing the broadest possible thing. I worry that for instance, on that issue, the idea that we would have 15 minutes and a scramble among, let's say there were 20 of you, which happens from time to time, that wish to speak in public comment. How do you choose who? Is it by who the chair chooses? Is it by cards coming in and the order of receipt? Is it by subject matter? I have no idea how we would sort that out, what kind of protocol would be perceived or in fact be fair and equitable for people. And I'm just not sure that that actually would work. However, if we did set some regular time for public comment, say 30 minutes or whatever the amount in the early session, I would not want that to be at the discretion of the board whether it could be continued to another specific time. I certainly don't think that the school boards that I've waited sometimes as many as 4 or 5 hours to speak to while somebody rattles on about some obscure point of bureaucracy, I don't think that's a good system. But if you were to take a public speaking section of half an hour in the morning and then a specified time later in the day that the board would continue it until it was completed, that might be another way to have 2 moments and opportunities for people on different shifts, even under the current schedule, to participate. Really, it's a combination. One person described this as efficiency versus democracy. I think there's sort of it is to some extent that, but there's also another element that seems missing here, which is courtesy. Right now, we're being tremendously rude to a bunch of people who came here to talk about the Williamson Act, all right? But we're still rattling on. So the final piece of this is that I think agenda review needs to have a practical assessment of what the likelihood. We can't always guess perfectly, but we can guess. But we can guess. But we can guess a little better than we do. And I'd like to see maybe a little more consultation on our guesstimates so that we get it more right. I could have guessed that this particular discussion would go on into 10:45, for instance. Just a wild guess, but it seems to be vindicated. Anyway, I could see some compromises if any of those meet your fancy, but I also, if it's between this proposal and staying the way it is, I would stay the way it is.
Okay, I'll give my comments then. First off, let me say I totally agree and been an advocate for a long period of time with Steve's comments that I think staff should come in under board correspondence and not under public comments, number one. Secondly, I'm an advocate of putting, and we did this for many years when I was first on the board, putting public comments at the end of the regular agenda. I don't know when it was the board decided to move it to the front of the agenda, but as I recall, it wasn't because of any public hue and cry to do so. And one of the reasons I would like it at the end of the agenda is because I really don't want to put a time limit on it. And if we don't have it at the end of the agenda, it seems to me we almost are compelled, we're basically compelled to have a time limit. I mean, you can't just go on and keep everybody on the regular agenda waiting indefinitely. So I don't think, where the board puts it on the agenda has anything to do with anybody's right to free speech. You can put it on the agenda anywhere. You got all the free speech you like. Also, I would just point out that, I think all of us have county email. We all have listed telephone numbers, I believe. You can call us. I get calls all the time. I meet with people all the time. I'd say probably at least half of the public comments could be answered if the person would just pick up the phone and call the appropriate department head. It needn't be just an ever-ending discussion sort of in front of the board that takes so much time where public comments really isn't sort of focused on some citizen coming in that really has an unanswered question and just like to get an answer to the question, express an opinion and go home. So having said that, I think I'm the only one that's an advocate for having it putting it back where it was at the end of the regular agenda, so we can get through all the time projects or timed issues on the a regular agenda. So if I have to go back then to, well, let's keep it at first up on the regular agenda, then I think we do need some time limits, and I would agree with, I think it was Steve that said a half hour. I think a half hour is adequate. And then we'll just schedule things thereafter, and when the half hour's up, it's up. And I think we should limit it then to 3 minutes per person. If we put it at the end of the agenda, then I don't think we need to do that. But I think if we're going to put it at the beginning of the agenda, we have a responsibility to others that have agenda items before the board that are scheduled on the agenda with backup information. I think we have an obligation to hear those items, just like we have an obligation, it seems to me, to be as close to 10:45 as possible to hear the Williamson Act issues. And we have 2 department heads sitting in back, and we have 3 or 4 or 5 members of the public sitting here that came in at about 10:35, 10:40, thinking we had a 10:45 item that they were going to be here for. And I think we have some obligation to move that regular agenda along, and I don't see how you can do it without time limits if we're going to put it at the front of the agenda. I don't think anybody's speech is being affected where it is on the agenda. I don't think anybody's being limited to picking up the phone and calling a department head or calling the Board of Supervisors. And quite frankly, if you look out here and see all the comments on this issue, it's basically all from Rancho and Valley Springs. I don't think there's one person that's given a comment from the Highway 4 corridor other than Joe. I think one person from Copper, which would probably be Al. And most people get their questions answered, and the county's very good at trying to get people's questions answered. And it needn't take up an hour or an hour and a half on public comments and push everybody else further behind. I mean, the people on the regular agenda, other people on the regular agenda, they have a right to be heard too. And their rights in some ways start getting compressed when we're running so far behind, and you see people starting to leave because they just can't, they can't spend that much time for an item that was scheduled. So if it is going to be at the front, then I think what we should do is something like Steve said. I think we should just basically take consent agenda item and take it to 9:15, and from 9:15 to 9:45 is public comments, and at 9:45 it gets cut off and we move forward with the agenda so we can schedule things and people have an expectation of having their items heard in a timely manner. I am for limiting also the topics. I mean, we had one issue in here from Valley Springs that went on for almost an hour, and it was really a political rally. And as we get into the next political season, if you're going to say basically that people can just come in and they can talk and there's no limits on the topic, then we're going to just have people who come in here and hold endless political rallies in front of the TV cameras and in front of the board, and this is where we should be having political rallies. And that's clearly what that was when that came before the board for almost an hour. So I think there has to be some control and some respect for the other parties that are on the regular agenda and have come in and done homework. That they paid money to get permits to get on the agenda. They have a right to be heard also. So if it goes to the front of the agenda, then I'm for 3 minutes and a half hour limit. Start it at 9:15 or something and go to 10:45 and then schedule the regular agenda. So
9:45.
I want to speak to that because I totally disagree with it. It doesn't make any sense. You're looking at our agenda, it says a regular agenda, and under regular agenda has public comments. If you're going to limit that time, then you got every item on this agenda you need to do the same thing to. We've had many times where community plans were on this agenda, the general plan is coming up, Trinitas, and a lot of other items where we had to reconvene at Town Hall. And there was hundreds of people that spoke. It took all day. It took 2 days, as a matter of fact. So if you're going to limit something on the regular agenda to a time limit, then you've got to do that respectively to every other item on this agenda and say the same thing. It's 3 minutes per person. When we reach the 30 minutes, we're closing public comment. We're coming back to the board on this item. You can't just do this to one thing and single it out. I don't think it's right. I don't think it's the way it should be. We got to give equal, and if it's not on this agenda, somebody has the right to come in this door and talk to us, because that's what it says. It says that any item that's not on the regular agenda, they have the right to stand up here and speak. And I'm not in favor, and will not be in favor, of limiting the time these people have to speak, or putting it off where 5 can stand up here and just take over on one item when, you know, there's a lot of people in the room that have 2 sides on it, and tell them, well, sorry, we're stopping here. We can't hear your side, or you have to come back at the end of this meeting, which could be 5 hours from now. We've had a number of items on this agenda where, like this particular one, it's taken over an hour right now. It's not going to, unless you limit it to 30 minutes to say now we're going at 10:45 on to this other item, you're not doing justice to our agenda or the public out there itself.
Okay, any other board comments, and then I'll do some polling. Let me begin by polling the board and asking, do you wish to keep it at the beginning, or do you wish to put it at the end of the regular agenda? And I'll start with Steve. Beginning or end?
Beginning.
Marita?
Beginning.
Gary?
Beginning.
Darren?
Beginning.
Okay, I'm for putting it at the end. Okay, so it's 4-1 to keep it at the beginning. Then let's talk about time limits. Do you wish to limit public comments as recommended by staff to 3 minutes, or do you wish to remain at 5 minutes? I'll start at Darren.
I wish to have it remain the same that it stands, with the caveat that the chairman has discretion. Like Mr. Caldwell, you gave him discretion to go on.
Yeah, okay.
Okay, so
there's always that.
Yeah.
But you don't have discretion to make it less. I mean, if it's 5 minutes, it's 5 minutes.
Right.
And discretion to go over. Okay. Gary?
Remain the same, and the chair has always had discretion.
5 minutes. Marita?
3 minutes with discretion.
Steve?
3 to 5, depending on circumstances. 3 to 5 at the discretion of the chair, depending on the number of people seeking to express themselves and the time frame in which we're trying to accomplish it. Oh, jeez. I thought I turned it off. I'm not very technically proficient, apparently.
I'm in favor of 3 minutes. So I guess what you're saying, Steve, is we have to publish something, so it'll be 3 minutes with the discretion of the chair to extend it to 5 or more. When I do it, I always look to the board for some direction if you want to extend it. Because when you extend it for one, you almost have to extend it for all.
No, the chair, you have the discretion, Tom. You are the chair.
Okay,
Your job is to manage the meeting. And
okay, then I guess we have 3 to 2 for 3 minutes on public discussion. Okay, then let me...
No.
I'm not talking about limiting it to 3. I'm saying that within discretion, it's 3 to 5, and it should be announced each item when we're doing public.
No, we're talking public comments.
Just public comments.
What do you mean each item? It's one item. Public comments is one item.
Well,
I want you to choose 3 or 5.
You need to pick 3 or 5.
Well, I'll take 5 then.
Okay, then it remains at 5 minutes.
If we're not going to count the people who want to speak and figure out whether we can accommodate it, then 5.
How you implement what you're recommending.
Well, you can implement it as chair discretion and look out there and see the number of people on one item and then limit it to 3 minutes. You have that discretion.
Well,
that's the point that I was trying to make.
I mean, if we don't have a set of rules, you're just going to really annoy a whole lot of people. And if you want to do that, I think you should do that when you're chair, because I don't know how you can just go back and forth. We need a set of rules to implement by. We're at the board now. Okay, so there's 3 that say remain at 5 minutes. Okay, then the question is, should we limit the amount of time for public comments? Several people had said a half hour, so I'll just pick a half hour. Should we limit it to a half hour? And I'll go with Gary first this time, and then to Marita.
No.
Okay, you want to just leave it open-ended. Okay, Marita.
Yes.
A half hour. Steve.
I want to, again, be real clear on this. I do not agree with the idea of half an hour and it's done. I believe that if we did half an hour, 40 minutes, whatever the time is, that if there's still more to go, that we should have a second regular part of the agenda where people can count on a time certain to complete it, and again, without limit.
I got it. But Steve, It's no different than all these people who've been here for over an hour waiting for an agenda item. So if you ask for a time certain, do we say, well, we're going to have to hold up this agenda item and all these people who came?
An alternative might be something like this. You take a time in the morning where you have an hour that could be devoted to public comment. If it does not take that up, we could put our closed sessions and other matters in that time
That's very
slot.
difficult to do. Closed sessions can go a long time, and you can't just cut closed sessions off. Either you want. Well, let me go to Darren. Where are you, Darren? I mean, we have two one for unlimited, 2 for 30 minutes. Where are you? Thank you, Darren. Was that a 90-yard punt?
Yeah.
Was that a squib kick?
It was a shank.
That was a squibber.
Yeah, that was a squibber.
That's a Steve.
So where are you?
When I go to Calaveras football games, I always see squibs these days, so I don't know.
Where are you, Darren?
You were punting out of bounds?
Yeah, out of bounds. In terms of, there's, logical reasoning to say that things should be limited and carried over till a later time. And the gentleman in the audience that talked about democracy versus efficiency, Steve spoke to that. And, I think this is something that we'll have to look at and maybe look harder at. And maybe some of the people that are here today that might not have been here 2 weeks ago when it came up originally, maybe there might be some more thought on it as to whether or not they would be willing or after having more time to think about it, if they would like to have a dedicated time at the beginning and at the end. But right now, clearly the message that I've been getting from people here that I represent as their supervisor, and as well as people that I've received correspondence with through email and phone calls, et cetera, there isn't a chance in hell that I'm going to vote for it to be limited right now.
Okay, so there's 2 that are unlimited, and there's 2 that are limited to a half hour. Steve, it comes back to you. Give us something that's workable.
Well, since nobody agrees with my efforts to compromise, as I said before, I'll stay with the existing circumstance with unlimited and
okay, you have 3 at unlimited, so we've changed absolutely nothing. Okay, is there anything else on this agenda item?
No, we changed Al's look. He's now smiling.
Did we at least get some instructions?
Are the Williamson Act people smiling? That's the question.
They're all smiling.
Okay, we are adjourning. We are going to adjourn. No, excuse me. We have reports and various matters of concern. Okay, let us go forward to reports and various matters of concern.
Want me to start?
And you want to start, Marita?
Sure.
Would you like to start? Excuse me.
Sure, I'll start. Tomorrow, Steve and I we have child support. I have, I'm on the Public Safety Technical Committee for the California State Association of Counties. I have that tomorrow. I have Administration of Justice for California State Association of Counties on Thursday. I have Treasury Oversight. I have Juvenile Justice Commission. And chairs for charity and Fish and Game Commission this week. That's it.
Okay, Gary, we'll go to you.
I'm not going to report the board, Mr. Chair.
Steve, we'll go to you.
Tomorrow I have the Rural Business Enterprise Grant Steering Committee meeting in the morning, Child Support JPA in the afternoon, and in the evening a very important meeting which I'd like to let people know. There are going to be meetings all over the county to try to develop a long overdue Community Wildfire Protection Plan, CWPP. Those meetings have been announced by the Fire Safe Council, and the first one is happening, I believe, in West Point on Wednesday at 6 p.m. at the American Legion Hall. This is an opportunity for people to put together wildfire protection plans and have public input to that about where and it's informed by CAL FIRE maps and a lot of other work that's been done. But we, as a county, have not completed these plans, which means that we are not eligible to receive funds to clean up our forests, to do thinning and clearing around the town. So our wildland-urban interface is considered by CAL FIRE one of the most hazardous in the state, and we're very ripe for catastrophic burns. The hope is that each community or each district at this point will participate in this and help formulate it so that we can then get the crews working out there in the forest around the towns in particular to a plan that has community support. So again, 6 p.m. on Wednesday for District 2 and anybody else, by the way, who wishes to attend from any place else. And there are several other meetings which I don't have in front of me for other areas of the county to participate in. On Thursday, I have the Sierra Cascades Dialogue Steering Committee. I have a Rural Business Enterprise Grant meeting on Friday, and the Conservation Resources Conference in Sacramento on Saturday. And the West Point, something else everybody should know is that Lumberjack Day Crab Feed is on Saturday evening, and there are still a few tickets left for the early seating. So if you want to go to Lumberjack Day Great Crab Feed, be there or be square.
Well, no, we have Cheers for Charity, too.
One other set of information.
Crab feed, too.
Yesterday, I attended the Motherlode Job Training Board meeting, and they issued the most recent statistics, which actually only cover up through November of 2010 for unemployment in a number of counties, including those part of the JPA. Amador at 13.1 with 2,300 people unemployed. Calaveras County, 15.9 with 3,130 people unemployed. Mariposa County at 12.8 with 1,190 people unemployed. Tuolumne County, 13.6% with 3,540 unemployed. The Motherlode as a whole, that's those four, that's Motherlode Job Training's jurisdiction, is 10,170 people unemployed. That's by government definition of unemployed. Doesn't include those who have given up and quit looking. At 12.4%. Comparable counties include Stanislaus at 17.2, San Joaquin at 17.5, Merced at 18.6.
A lot of people.
Mariposa, I've already done Mariposa. Madera at 15.7. California as a whole is at 12.4. So the Motherlode and rural counties are being hit disproportionately and severely. This is the highest unemployment statistics that we have seen in the course of my 6 years on the Motherlode Job Training Board, and there has been little movement in the last year.
Does that complete your comments?
Yeah, sorry to be depressing at the end, but the crab feed was a good thing. So
Well, it'd be interesting to single those out and find out how many are actually construction jobs, that the percentage.
by sector.
Yes.
I'll try to get that for next time. I believe that is available.
Darren, do you have comments for the board this morning?
Yeah, having come from, growing up in the valley, a lot of those numbers that you see are typically high over long periods of time are agricultural and construction related, which always take a big hit whenever the economy goes down a little bit. But I'll be meeting tomorrow with Dave Pastizo and members of the planning department, and also Mr. Ellert from Lundgren's office and Kathleen from FEMA. We're meeting about FEMA flood mapping as it pertains to the northern area of District 5, which is big on a lot of people's minds right now. Other than that, I've got a laundry list that would take too long, and we all would like to recess. So I'll leave it by saying that I'm giving an extra half hour on my Thursday meetings. I'll be at Rancho from 12 to 1:30, and in Comper at Snaps from 2:30 until 4. So far, I've exceeded the hour in both of those locations, so I'm bumping it to an hour and a half, and we'll make adjustments as necessary. So.
Sounds like you're fully employed.
Apparently, yeah.
Okay, I'll come to myself. I did attend the Regional Council of Rural Counties meeting in Sacramento last week, and I'll give you that update. We're all aware that there is going to be called a special session to vote on the extension of a lot of tax increases, a little over $12 billion in tax increases. The Republicans have stated that they find it unlikely that their caucus will provide the votes necessary for a two-thirds vote to put this on the ballot. So the Democrats are trying to look at a way to do this, to call the special session on a majority vote, and that revolves around doing it sort of within a budget bill, because of the change that allowed a lot of things to take place within a budget bill, not the tax increases, but to call the special election. Some key uses and changes in the proposed budget by Governor Brown. Well, first off, they anticipate another cash flow crisis coming to California during the summer, and are suggesting the need for deferrals of state payments to meet cash obligations. I don't know, what state payments to the counties. These are not been defined yet as to what state payments to counties will in fact be deferred to conserve cash for the state. Key issues for RCRC members, and it was in our board packet this morning. I noticed when I did the review. But the Williamson Act subventions have not only gone to zero for the coming year, but he's taking $10 million out that was put in last year. So there are a lot of counties out there that allocated Williamson Act subventions for the current fiscal years, and that money is now being taken out after the fact. And so that's affecting some counties. The other, and I'll get into this in a little bit more, the restructuring of CAL FIRE services in the state responsibility areas. This may have an effect on us. All of Calaveras County is a state responsibility area with the exception of the incorporated city of Angels Camp. And then reenacting the gas tax swap to preserve state and local transportation funding. The governor's proposed budget requires counties to provide custody, rehabilitation, and post-incarceration supervision for all juvenile offenders, thereby eliminating the division of juvenile justice at the state level. Funding for this realigned responsibility would come in part from the extension of sales taxes and vehicle license fees, which is contingent upon the voter approval in June. Okay, it does talk about how in the budget there is money put in for the Calaveras County Replacement Jail. So that's even in at this point. So hopefully it will stay. The other interesting, and it was talked about just sort of briefly, is the governor's proposed budget provides $364 million, representing a decrease of $20 million from last year. This is for the Department of Food and Agriculture. Of note is the permanent $32 million decrease in general fund revenue as a result of removing state funding for support of the 78 local California fairs. Apparently there is funding for the fairs in this year's fiscal budget, like the fair at Frogtown, but in the proposed budget there is zero funding for state fairs for the coming fiscal year. How that's going to affect, whether this will stay in the budget, because there's a lot of support in rural areas not to do this, and this is the proposed budget. But right now, as proposed, there will be no funding whatsoever for the 78 state fairs in the state of California. State responsibility areas. The governor's proposed budget addresses the issue of state responsibility areas in a different way than the traditional SRA fee, state responsibility area fee. For a long time, they wanted to put a fee on per acre on state responsibility areas to fund CAL FIRE. He is not proposing to do that, Governor Brown. The administration seeks to limit the cost of CAL FIRE's activities within SRA's, state responsibility areas, by directing the Board of Forestry to investigate and redraw the maps for state responsibility areas to eliminate those state responsibility areas that have become more densely populated and require local government to assume responsibilities for these lands. The administration estimates this will save CAL FIRE approximately $250 million. So there's no funding that comes with the loss of with the assumption of state responsibility areas. And what is not determined yet is for where it says for those areas that have become more densely populated. Nobody knows what that definition is at this point. Will that include the community centers in Calaveras County? We don't know. But there is a possibility that a lot of our local fire districts, whether it be Murphy's Fire or Copper Fire or some of these, are going to be assuming responsibilities with where in the state responsibility area map to be withdrawn may take some of that away, and so that could have a very significant effect upon our local fire departments, depending how that's defined. Steve's probably aware of this, and you may have even told us this, Steve, but the governor's proposed budget provides $4.8 million for the Sierra Nevada Conservancy, which is a reduction of over $25 million as a result of the reduction in the bond funding. So Sierra Nevada Conservancy is going from $25 million a year to 4.8.
And just to give you an example, there's a 3-acre preserve outside of Los Angeles that gets $25 million, and the Sierra as a whole is going to get this.
4.8.
Yeah.
That's the proposed budget.
Just
I
think
just
about
wish to
the politics
reemphasize
of
this
that.
is the proposed budget. This is not an adopted budget. So obviously all of these will be hotly contested. Under state parks, they want to close some, and they want to close those which they are defined as low use, high cost. Of course, nobody's defined what low use and high cost is, and we have no definition of any of the targeted state parks. I don't know where Big Trees, I think we only have one state park in our county, Big Trees. Of course, we get ancillary business from Columbia State Park and other facilities, so nobody knows what that definition of low use and high cost is going to be. Okay, the reenactment of the gas tax swap, and this is last year where the state eliminated, I don't know why we have to make everything so complicated, but the state eliminated the sales tax on gasoline and replaced it with a 17.3 cents per gallon excise tax increase indexed to keep up with the sales tax on gasoline, which would have generated in a given fiscal year to ensure true revenue neutrality. They did that because I think something was passed by the citizens on a initiative that said you couldn't touch this, but you could lower this and put a new tax on to replace it, that then gave discretion to the state legislature. The new excise tax that was put on last year allocated 44% to State Transportation Improvement Program, the STIP, 44% to local streets and roads, which is ourselves, and 12% for highways, and then a tax on diesel to fund public transit. And that, if it doesn't get, the passage of the validation of the swap will not be easy. So this has to now be voted on. Under Prop 26, a reenactment of this, because I think it was set to expire. So the citizens passed Prop 26 here within the last year, one of the elections. Under Prop 26, a reenactment requires a 2/3 vote in the legislature, which means that Republicans will need to support the reenactment, even though there was not one single Republican vote for the swap last year. So if they don't get Republican support, which I think is like 2 or 3 members, we will take a very huge hit on our local funding for local roads, because most of a significant part of our funding for local roads is tied to that tax swap. And so they're asking, I think, Jeannie, I think you received emails from RCRC. I know Public Works, they said all Public Works have received emails saying, you know, that they want us to list all the projects that would be impacted if that swap is not passed. And so obviously what they're looking for are Republican support, and so they're going to the rural counties, and they're telling the rural counties that, you know, you're going to take a big hit on your road funding if this is not passed, so please put pressure on your local Republican legislators to vote for this, to vote to continue the tax swap that was initiated last year. This is a good one. memo that RCRC gave us summarizes a California Public Utilities Commission, the PUC, staff report titled Implementing a Public Goods Charge for Water. So what they want to do, the staff does, and is making a recommendation that a tax be imposed. And they say that the staff report from the Public Utilities Commission states, ultimately the report recommends a public goods charge for water because a public goods charge for water creates a price signal for water conservation. So they want to raise the cost of water because then they believe that will create increased conservation, which it will. If you raise the price, you'll get less. A public goods charge for water would provide a stable, sustainable funding mechanism to support the full list of conservation and efficiency activities specified in AB 32. So you guys can talk about that at next week's public comment period. The dual energy and water conservation programs specified in AB 32, which could not be fully funded through the other mechanisms considered, will be effective to both mitigate and adapt to climate change. The proposed implementation strategy will help institutionalize regional water agencies, which are necessary for the state's long-term water policy. So that they want to start driving us to regional water agencies rather than just local or just county water agencies. Specific recommendations made about the design of the public goods charge include the passage of state legislation requiring all water providers to assess volumetric surcharges on each water bill where metered or by alternative means in the short term for areas not metered. That the funds be managed by regional joint powers authorities, JPAs, to implement integrated regional water management plans, and that the Department of Water Resources provide direction and oversight to ensure that specified state goals are met and that funds are well managed. Those fees initially be set to raise $680 million per year. The recommendation to have the funds managed regionally and to have the fee be a volumetric, am I saying that right? Volumetric increase. The recommendation to have the funds managed regionally and to have the fee be volumetric increase the likelihood that the public goods charge will be considered a fee, not a tax. The creation of the public goods charge could complicate the overall scheme of water fees since RCRC, the Regional Council of Rural Counties, and staff anticipates a wide variety of fee proposals relating to water be put forward this year. And then they'll give a list. So apparently everybody is, additionally, a number of agencies are eyeing water-related fees to fund programs that are appropriately funded by the general fund, but have had this source of funding cut or eliminated over the last several years. So everybody's wants water money, water fee money, and the state wants a new fee to implement basically AB 32. Okay, under the building codes, we've had some discussions under the building codes that were implemented, the green building codes that were implemented on January 1st that require indoor residential fire sprinklers. One of the other issues is during the single-family fire sprinkler presentation at the December RCRC board meeting, Mr. Rayner from the California Business Improvement Association, anyway, it's a business, it's a contractors, basically home builders association, mentioned that the Home Builders Association is more concerned now with the CEC's upcoming new energy efficiency standards. In 2002, California adopted their first energy efficiency requirement to reduce energy use by 15%. This was followed by another 15% in 2005 and then another 20% in 2008. The CEC is now developing a new mandatory energy efficiency standard of another 15 to 25% reduction and 2 additional voluntary reduction levels. Even though the levels are some of the additional levels are voluntary, they would still require building departments to have the capabilities to review, document, and inspect, and require substantial increase in paperwork, verification, and monitoring. The voluntary levels may require third-party classification, which then adds a new level of coordination for the building departments. The Builders Association, this is their number one issue for the coming year. So,
why don't they just come out and say they don't want a single new home to be built in the state of California?
well, you know, I was under one of the public comment periods, the beginning to the second, where somebody talked about, you know, what are we doing for economic growth in California? We're doing nothing for economic growth in California. This is another interesting one. The State Water Resources Control Board has proposed a policy for toxicity assessment and control. And this would place strict toxicity requirements on a wide range of water dischargers currently covered under various permits and waste discharge requirements. The toxicity testing method, however, and frequency has the potential for many unintended consequences that may make the requirements very difficult for dischargers to meet. According to the California Association of Sanitary Agencies, some of the potential problems include the first, the toxicity test outlined in the policy has a 15% false positive rate based on evaluation of EPA data. Second, probability of failing at least one chronic toxicity test is 86% over the course of 1 year and more than 99.9% over the course of a 5-year permit cycle, even if the discharge was actually non-toxic. Thirdly, the policy will lead to numeric toxicity limits for nearly all dischargers. And fourthly, essentially all waters of the state will be listed as impaired for toxicity. So wait till that economic issue hits and the mitigations for it.
Who wants to tell the people on Tulloch that nobody can use boats over there anymore when that comes out? Or New Maloney's or Comanche or whatever.
The other thing RCRC is fighting is there's been a recent federal proposed rule relating to the Housing Trust Fund, and RCRC is very much trying to change one of the definitions in there. The Housing Trust Fund proposed rule contains a proposed definition of wetland that differs from the widely used Army Corps of Engineers definition. In fact, the proposed rule specifically states this definition is independent of the definition of jurisdictional wetland used by the U.S. Army Corps of Engineers under Section 404 of the Clean Water Act. And so basically, if this goes through, you're going to have two definitions of wetlands. And that to RCRC makes no sense at all. Thinks you know, just to place it on housing, you know, already the 404 permit's almost impossible to get. So putting a new definition, federal definition of wetlands onto housing is something that RCRC is very much opposed to. Okay, I think that completes my RCRC report. Are there any other board comments on any issues?
Can you show us a little bit more, sir?
That's our economic growth program in California for the coming year. Jim, do you have any comments? Janie, do you have comments for the board today? Diane, do you have any comments for the board today? Okay, that completes the review of correspondence, reports, and various matters of concern. And we will stand adjourned from our regular agenda. We will reconvene in study session, you know, an hour and probably 10 minutes late, because let's take about a 5-minute recess where we can all stretch our legs. Thank you. Okay, whoops, are we on? Wait a minute, let's get on.
Well, now we're on. The room
Okay,
room might
Leslie,
take a while.
please proceed.
Hold on. Before we proceed, I'd like to discuss a matter of procedure. And I may, as you know, my property is in the Williamson Act. As I understand, while this is a study session, that there are likely to be directions to staff in one direction or another. Either one may or may not benefit or harm my individual interests. I've been informed by County Council that this is not a conflict because it is a policy affecting many, but at a standard of perception, I'm going to excuse myself from this discussion.
No, wait. You know, Walensky, you're just doing that because you want to go somewhere and have lunch and go meet with people, and you don't want to stay here and listen to what the ag community is telling us.
No, actually, I have very strong feelings about this and would like nothing better than to stay for the conversation. And I do believe that I could separate my own interests from the public policy issues, but at the same time, I think the standard I wish to abide by is one I hold personally, and I will leave as a result of that.
Okay, well, let me just say that I also have land that's under the Williamson Act contract, and as Steve has indicated, County Council has indicated that is not a conflict for me to sit in and either give direction or vote, because however it goes, it goes the same way for everybody within a Williamson Act contract as opposed to just myself. And Jeannie, you might ask Jim to come in and reiterate that statement if you would, just so it's in the record.
But can we go ahead and start?
But my own feeling is I was elected to vote, and if I have a legal ability to vote, I'm voting. And if I don't have a legal ability to vote, then I won't. But I'm not interested in recusing myself because somebody thinks it's an appearance of something. Yes, Peter.
You do have a right to vote out of vote of necessity to get a majority.
Well, there's three.
I mean, I'm sure you're telling though.
Yeah. And quite frankly, if I recuse myself, that's a vote basically not to change anything because it takes 3 votes to change something. So Steve's vote is basically a no vote. I could recuse myself because, quite frankly, I don't see myself in favor of changing anything, and which amounts to a no vote anyway, because you still have to have 3 positive votes to make a change.
I want to compliment you to give the appearance of actual conflict of interest.
So, I mean, if the council says I have a conflict of interest, then I'll step down in the blink of an eye. But it still represents a no vote. You still have to have 3 positive votes to make a change from current policy.
And I wish I was in the Williamson Act, so does that count?
Me too.
Well, the Williamson Act does not include residences. It's just basically ag land. So
I have ag.
yeah, you have ag.
I have goats on my 4 acres. Does that count?
Yeah. Marita raises star thistle for sale.
I do.
Oh.
So anyway, let's just take a 3 or 4 minute recess and get Jim in here to
We'll
put something in the record.
We'll get started here pretty soon.
Okay, we'll get
turn
started.
the mics on.
Oh, turn them off. Yeah, I thought Jim was. Williamson Act contracts. I'm in the Williamson Act. Steve is in the Williamson Act. Steve says he feels that there's an appearance of conflict, so he has recused himself. If I have a legal conflict, I wish to recuse myself. If I don't, I wish to participate and vote. I feel like that's what I was elected to do. And agriculture is a constituency of mine, and it's a constituency, and these are issues I ran on. So do I have a conflict, and do I need to step aside?
Well, this question came up several years ago in the same context, Williamson Act question, and I looked at it then.
Here, speak into the mic, will you?
The Fair Political Practices Commission has a variety of very complicated regulations that go through a lengthy analysis to determine if a public official has a financial interest in a vote. Obviously, you can't vote on something that has a financial interest for you. One of the exceptions is if you're in the same position as the rest of the general public. If the benefit to you is the same as the benefit that accrues to the rest of the public. Now, that's not everybody in the county. That the public, the general public, is defined by one of those regulations as a substantial segment. So I told you this is complicated and it's very bureaucratic, and maybe not all logical. But so there's a variety of rules to determine whether the effect of this vote will have an impact on a substantial segment of the population. In the case of land, it's 10% of the jurisdiction, within the jurisdiction. So if what the board is going to do has an effect on 10% of the land in Calaveras County, then you are just one of part of a substantial segment, and by that definition have no conflict. There's no conflict of interest. So
well, it seems to me. Then the question is, how do you define 10% of the land? Is it 10% of the land within the Williamson Act, or 10% of the land that would be eligible to go into the Williamson Act under the current regulations?
I took the view that was 10% of the ag land, because the ag land is either in or could be in.
Yes.
The Williamson
Act.
There are probably.
I don't know. Is that 10% of the land? I would think so, but I don't know that for a fact.
Well, we've not run the numbers of 10% of all ag land, but there's about 135,000 acres in the Williamson Act. Do you have 13,000?
I have what?
Do you have 13,000 acres?
In my dreams.
So he doesn't even reach.
Do I look like a Garamendi or a Tiscornia to you?
So under probably I guess the most strict analysis, you don't have a conflict.
Okay.
So that was my recommendation when it came up before, and again now.
Okay.
As I've always said, the Fair Political Practices Commission doesn't take its advice from me. You always have the option of talking to them and getting their opinion.
Well, it's kind of late in the day for this study session. Maybe what I should do is recuse myself and have you contact the commission to find out if there's 3 votes to change this or not, then I can vote on it when it comes back on the regular agenda.
I have to tell you, for this, that's the most conservative thing before you to abstain.
Okay, then I think I'll do that. Just so
the Fair Political Practices Commission.
And then why don't you check with the Fair Committee, because this has come up before.
The difference is, for your benefit, the Fair Political Practices Commission says there's no conflict. They give you a letter, and that guarantees that you're safe.
Well, why don't you ask for both Steve and I, and then that takes the issue off the table. Okay. And this is a study session, and if there is no conflict, then Steve and I would be able to sit in when if it comes back. I mean, if the board, if they pull the board and there's no and there's not 3 votes to change it, then it doesn't come back and it becomes moot. But I still think you should ask the Fair Political Practices Commission, because it will come back in some capacity at some time.
So there's no final decision being made today on this.
No, but I would like that.
Direction will be given, and direction is going to be given on an ag issue by 3 non-ag people.
Well, but all it's just 3 votes anyway. So I mean, you can either support the Williamson Act or not support the Williamson Act. And if Steve and I both had a right to vote, and both want to represent ag and want to represent open space and not in favor of a lot of rural sprawls and breaking up the ranches into 5s and 10s and 20s and 40s.
It sounds like an editorial opinion to me, Mr. Tryon. Either you leave or you stay.
Well, I haven't opened it yet.
Well, you have an opportunity to make that presentation here. Again, if you're going to recuse yourself, then you would leave the room. But you can make your comments before you do that. So you're not deprived of your right to speak on.
See, I have a right to free speech. Didn't you hear the public comments?
Peter's got
2-hour discussion.
Peter's got.
Brian, can you move over a seat and let Tom sit next to Peter?
Do I have to leave the room, or can I just sit in?
You should make your. I think you need to make the comments and then leave the room. Yes. If that's the procedure you're going to follow.
I'll just leave the room.
So
you will check then with the Fair Political Practices Commission and get a reading on the Williamson Act.
I will assist you in doing what you have to do, but I'll assist you to do it.
Okay.
I'm just taking it because it's there.
No pressure on you guys, but don't screw this one up.
I'm not sure you understand what it is, Tom.
Thank you. Does it require a woman's intuition to tell what it is?
Read the law.
All right, Tom, all right. Having said that, I've been given 2 members to abstain and leave the room. Let's proceed.
Mr. Chair, honorable members of the board, I'm Leslie Davis, County Assessor. I'm delighted to have with me today your County Agricultural Commissioner, Mary Mutz, who's been a great help on this presentation. We both sat at the back of the room and listened to your thoughts during the public comment debate, and we're aware of the fact that this agenda item should have started at 10:45. It was scheduled to take an hour. We're well past that, so I can cut to the chase and tell you that we recommend against implementation of Senate Bill 863, and if you agree, we could just go. Or we can give you a little bit of background and let you reach that conclusion all by yourselves.
Why don't we proceed? And if it gets lengthy, we can make you give us the Reader Digest version.
All right, I can do that.
Okay.
But I still have to start back when I was in middle school and the California Land Conservation Act passed in 1965. Essentially, when Williamson Act contracts started in 1965, there was some debate statewide about how those properties should be valued. So the public stepped in and passed a constitutional amendment requiring assessors to value properties subject to these contracts, subject to the restrictions that were contained in those contracts. The subventions that became such a hot issue over the last few years did not kick in until the 1970s. You fast forward then to earlier in this decade when Governor Schwarzenegger was in office, he removed the subventions, or actually reduced them to a nominal amount, essentially reducing them to zero. You might remember that in October you passed the resolution allowing us to file for the open space subvention, and the amount of our open space subvention application in October was $136,544.06. Senate Bill 863 passed during this past legislative session that essentially allowed counties to reduce, well, they're calling it reduce the term. Technically, that is not the way the value is calculated. But reduce the term of Williamson Act contracts from 10 years to 9 years and add a direct charge on tax bills that reflects 10% of the difference between the value that they would have paid in the unrestricted state, what we call a factored base year value, and the tax that they would pay on the restricted value. That is completely different from the calculation that would exist if a property owner non-renewed for their first year and had an actual 9-year term. The Senate bill does not apply to properties with conservation easements that we value as restricted, and it does not apply to properties within cities. Fortunately, or unfortunately, depending on your perspective, Calaveras County only has one city. So we get down to about 1,099 assessor parcels that would be affected by this.
Well, excuse me, 1,099?
1,099. Using last year's numbers, not this year's numbers, because we have no way of knowing what this year's numbers will be until the assessment roll closes. About 473 of those parcels would have a direct charge less than $20. And about 112 of those would have a direct charge less than $1.
Leslie?
And there's no provision in this law for you to pick and choose. It's all or nothing.
So for the 1 year that they're taking out, we're reclaiming $20 on 420 of them, and $1
for less than 112.
For less than 112.
Supervisor Callaway, I'm sorry.
I'm not real sure I'm following that. If you're getting a $500 tax benefit and it's 10%,
that would be $50.
Right, so that would be the $50 that then would go to the county's general fund?
Correct.
So what you said is that there'd be 20, just average would be $20
I'm saying less than 473 of the 1,099 parcels affected would have a direct charge less than $20. And 112 would have a direct charge of less than $1.
I guess what Supervisor Callaway is asking is, do we have a medium on what the dollar amount medium-wise would be?
The average dollar amount would be about $89.75. The mean is $28.27. So there's many above $28 as below $28. This is a lot of work for nothing. The net return to the county general fund is about $98,500. And that figure is important because in order to implement this law, you have to determine that we did not receive an open space subvention sufficient to cover half of the property tax revenues that are lost. The property tax revenues that are lost are actually $172,378. Now, we really don't have to do any calculations after that because we haven't gotten a subvention in several years. So the answer is we've already met that finding or that criteria. Then you have to notify landowners of your intent to implement the law and advise them of their right to non-renew the contract. Then you have to hold a public hearing in which the provisions of this particular law are adopted. And then you have to tell the local officials responsible for implementation, which include the assessor, the auditor, the recorder, and of course the agricultural commissioner, because we've all got pieces of this puzzle that have to come together to implement this particular law. As of mid-December, 6 counties had decided to implement the provisions of Senate Bill 863. 14 had decided not to. 1 county decided to non-renew all Williamson contracts. You'll remember that your board was asked a year or two ago when Governor Schwarzenegger started reducing subventions whether or not you wanted to non-renew all contracts, and this board decided against taking that kind of action. This is a law that sunsets January 1st, 2015. If you were going to implement it for the current year, you had to do so by next Tuesday. Oops, you missed that. So this year, it's a moot point. If you decide that you want to proceed, you have to implement 90 days before next lien date, which means, for those of you who remember your assessment appeals day, 90 days before January 1st or September 30th, 2011.
So how come we didn't deal with this when we had the opportunity for this tax for November, December?
On a very personal level, and without whining, I have staffing issues to deal with, and I have constitutionally mandated duties, and trying to deal with something that's not mandated by the Constitution really falls low on my list of priorities. And let's be also aware that public officials tend to implement policies simply by dragging their feet. I've already told you I recommend against this. I can give you my reasons why. I don't think we could have gotten the work done.
I just felt like we had to ask the question because I knew about the November, December. Thank you. Not that I agree, but thank you.
You say?
We'll be happy to answer any question you might have about it, including, I don't know what Mary's reasons are, but I'd be happy to tell you my reasons for recommending against it. Supervisor Spellman?
Recommending against it would be an inaction by the county. In other words, that's what you're advocating for, just to leave it as it is right now.
Correct.
You said that in your estimation there would be a net gain to the county of $98,000. Is that when you back out all the projected costs, the difference between the 172, then when you take out whatever costs are associated, then you come up with the 98? Is that how you arrived at that number? Or?
No, the $98,000 would be the total amount of direct charges on the tax bills. It is not net of any expense on a department-by-department basis. So while the agricultural commissioner has been able to do calculations about what she thinks the cost will be, I've not asked the recorder for an estimate of their cost because until this board takes an action to implement, I don't know if the approach you'll take is to require recordation of each individual amended contract or to take the approach of recording a list of all affected contracts as part of the official record. I have, at this point, spoken to Megabyte, our property tax vendor, and they have indicated that they will do the programming necessary for the auditor to add this direct charge to the bill at no additional cost. However, we don't have that in writing, and I'm a little concerned about making a promise for a vendor when I don't have something like that in writing. It's very clear to me that the auditor's office, who is going to calculate a bill with maybe a 35-cent direct charge is going to be deluged with phone calls, and they won't be the only department. My department can expect a number of phone calls because this will be the first time the agricultural community will be seeing a calculation that includes their factored base year value. And I just use Supervisor Tran as an example, if I may. If he has owned his property pre-1978, which means his factored base year value was established by the constitutional amendment that was passed then. He has not had constructive notice of his factored base year value for 33 years. This will be the first time he will actually see it because he's been getting restricted values all along. And I'll bet that we'll get phone calls for that, and probably even a person or two wanting to file an assessment appeal, which again is a domino effect on the recorder clerk of the board's office. So it's really hard to calculate what it's going to take us in terms of staff time to deal with these questions and issues.
In the discussion summary in the board packet, I'll just read one sentence here. It says in the second paragraph, in fiscal year 2009-2010, Calaveras County submitted an application for open space subvention in the amount of $136,461.60. However, then Governor Schwarzenegger reduced the open space subvention funding, yada, yada, yada. So in 2009-2010, we submitted a bill to the state for $136,461, and we got $1,000.
We didn't get
Or we got Zippo.
That was the total amount for the 58 counties was $1,000.
And all of the cities that have
Yeah.
property.
Okay. So we got Zip, but we asked for $136,461, which was the appropriate number. So assuming that would still be the number today, and this has a sunset in 2014. You said
2015.
2015. So we have a 4-year window because we missed the first one. So we've got 4 years at 136. So just for averages, say rough average, we're talking about $500,000 the county would have to cough up.
You would not get $136,000. You would only get the $98,000 because this is an open space subvention, which is based on $1 per acre of non-prime land and $5 per acre of prime land. It's a completely different calculation. The 98.5 is based on the factored base year value minus the restricted value times 10% times 1%.
So when we do all the actuarial calculations, it comes down to $98,000
per year for 4 years.
For 4 years. So we're talking roughly $400,000.
Correct.
Any other questions from the board? Okay, I'm going to open it up to the public. Does anybody from the public like to come up and speak?
Yeah, Will Moore from Valley Springs, and boy, what I'm hearing here is a total lack of interest or discussion of what the Williamson Act is. Its purpose is to preserve ag land. Its purpose isn't to tax or not tax this individual or that individual or collect money for the counties. Its purpose is to protect ag land from urban sprawl. That was what started it in the first place. I was a surveyor in the Santa Clara Valley 50 years ago when we plowed out all of the prunes in Santa Clara and planted houses. And this whole urban sprawl thing is happening. This San Joaquin Valley is soon going to be a city from Bakersfield to Sacramento. The whole purpose of this Williamson Act is to preserve ag land from development. It isn't about $98,000. Hey, we live in a hungry world. The population of this planet is going to reach 7 billion people this year, and we're burying all of this ag land. And here we are discussing it over chicken feed. Thank you.
Anybody else? Peter?
Just an offhand remark. As much as I agree with you, many, many years ago, and Leslie probably familiar with, we had a little issue back in Discovery Bay, and we had all sorts of supporters, matter of fact, financing some of those big ag lands. And those folks were all great for open land and farming and so on until it became financially feasible to develop. Okay? Now, I believe the Williamson Act, when it was taxed financially feasible for those people, to stay in that. They stayed. But when the opportunity came to cut it up and develop it, they chose to get out of it. Now, I fully respect large landowners' right to develop their land. I support that. Okay? How it's going to be developed down the road, that's going to be up to the supervisors because they're going to set the zoning and so on. But if they get a tax break, financially feasible for them to keep it in the Williams Act, let them do it. Because, and way above my pay grade, but what actually the net amount that the county would get compared to the net amount that the landowner will paying, there's a substantial amount of difference. And it's going to be all dripping off to all different kind of entities in between the county and the payers. Am I misunderstood it? Please straighten me out.
You did. Let me do clear up one thing, Peter, and I won't go back to the Discovery Bay days. You're remembering in the 80s when you could jump out of Williamson after a window period. This is different. All of the dollars...
I apologize for asking your question.
Oh, no, that's fine. But how many people are going to speak? Hands? Anybody else going to speak? That's fine. If nobody else is going to speak, then you can answer. Otherwise, I'd rather wait to answer all the questions at the end.
All of the dollars that are generated from implementation of Senate Bill 863 go directly to the county general fund. They are not shared in any way with any other jurisdiction.
Okay, nobody takes a percentage out of it.
No fire, nobody.
Okay, it goes to general fund.
Correct.
And you mentioned a dollar figure that is going to cost you to do the study that actually implement it.
The Ag Commissioner knows what it will cost her. I don't know what it will cost.
But it is going to be a cost attached to it.
It will be.
Okay, and we would be looking at some of the folks' input and challenge.
I'd expect.
Okay. But you have no idea what it's going to cost eventually. Okay. Thank you.
You're welcome. Anybody else? Okay, I'm going to close public comments and bring it back to the staff for final comments from them. There's recommendations.
Essentially, Mr. Chair, I would just, and I'm happy to answer any questions you have before we summarize.
Okay. Marita, you have another question?
Yeah, I have, I guess, comments. We've lost the subvention funds of $136,000. In 05, it was $197,000 we had. The general fund received. So we're losing that. According to the staff notes, it costs the Department of Ag, our Ag Department, $50,000 to manage the Williamson Act every year. So we've lost $136,000 to the general fund. The general fund is paying $50,000 to manage the contracts. So I'm saying we've missed the window of opportunity now. We still have time. I mean, why can't we take a look at it? And if the average cost, because the people in the Williamson Act get a tax break for being in the Williamson Act. The Williamson Act, yes, was meant to preserve ag land and open space, but by counties or cities or counties doing that, we receive subvention funds. We no longer receive those subvention funds. This board is saying we will continue to accept new contracts. Other counties have said we're going to take what we have, but we're going to do not accept any more. So, I mean, it's all over the board. I think we should look at it some more. If the average cost, additional cost, is $89.75, and the median is $28.27, and it's costing us $50,000 to manage the program, and we've lost $136,000, then shouldn't we at least take a look at it? And in terms of questions, I think part of it is an education program. We have the Cattle Association, we have the Farm Bureau, we have the grape growers, and when we have all these venues in the county where we can go out and meet with the community, and we could say, this parcel is going to pay $20. This parcel might pay $200. I mean, we don't have a clue. And that's general fund money that goes to, that we are using, that I am telling you, this coming year, we're going to wish we had $98,000. I mean, we've already heard the whining. I'm teasing Leslie, but I mean, she's just the start. And if any of you've talked to any of the other departments, we're going to hear it at budget time, and we're going to wish we had $98,000. So I'm not saying no. I think we have to say no because we've missed the opportunity that we should take a look at it and see what it is. I did go to Madeira's website, and they had a list of all their parcels, what the 10% would be, and what I think the tax benefit was to the individual parcel owners. So I don't know how they did it quickly. Maybe nobody cut their assessor's office in Madeira County, but I'm not willing to say no. I'm willing to take a look at it. But the other point is, if you don't have to be part of this to go after subvention funds. We can submit for subvention funds and take whatever might be our prorated share, with the exception. I feel like I need to do a Watergate moment and turn the button off. We owe the state money. So what,
300 something.
by not, does that mean then we should apply for the subvention, and then the state says, yes, Calaveras, you're going to get X thousands of dollars.
Of credit.
We know it won't be 136. Will they then take that off of the money that we owe them for Williamson Act?
Did you want me to respond to that question? Sure. That question is impossible to answer. We know that when the state audited us, the $197,000 figure that you threw out there first was determined to be incorrect. And so they went back and they calculated how many years, 5 years, how many dollars were overcharged. And they essentially told us, you owe us $330,000 and some change. They also said that they were going to take that money out of subvention dollars that should have come to the county. It's my personal opinion that since the state knew they were owed money, they should have taken their money first before they did anything else. And how they dealt with that, I don't know. But I do know that for the past 3 or 4 years, not only have we not received subvention monies, we also haven't heard hide nor hair from the state about that money that we owe them. And I have said publicly, although I saw you look at the camera behind me, and I certainly understand that, I don't think we need to be saying this out loud in a lot of venues. I think it's one of those out of sight, out of mind issues. Someday the state may come back and say, you owe us this money. We yanked your subventions, but hey, we want our money back. But they haven't done it during the time frame that I expected it to be still in their thought process. By now, I'm sure they've had enough staff changes nobody remembers.
Oh, right.
Well, now that it's on public
Leslie,
record, so.
Since we don't have to implement a program to go after subventions, I'm assuming we're going to go after subvention funds.
We submit the application every year. My office prepares the application and the map. We bring it to the board for approval, and we submit it to the Department of Conservation every year. Knowing full well we're not going to get $1.
Well, I mean, if Governor Brown has his way, the $10 million, as Tom mentioned earlier, is off the table.
I think we should plan on that $10 million being gone.
Yeah. But we'll still submit We'll still submit.
We already have.
Okay, so I think we should. I would like to know. I mean, you said 98,000. I take it, but that's adding up all of how much the $89 or $28 per parcel.
Or
And I
$20.
guess I would ask the ranching, the ag community. You know, this is we've taken a hit to the general fund, a significant amount. We've said we're going to continue the program. We're not cutting it off. We're accepting new contracts. Why not at least take a look at it? And so that's kind of where I am, since we seem to have time. Now, that being said, I don't know what it would take for us to do what Madera County did and list all the parcels that were under the Williamson Act and show how much, I think it was Madera, and show how much each parcel would have to pay.
Madera County, Stanislaus County, and Yolo County have on their website a lookup table. All three counties are in megabyte. So I already know what they did to set it up. We would need to change some programming and borrow their basics.
Okay, so.
But you said Megabyte was willing to set up
For the direct charge. Megabyte
for the direct charge, not
website lookup.
Well, how did they, well, Madera County, Stanislaus County are going with the program, Kane County, and who else?
Yolo.
And Yolo County. So how did they do that? Is that
How did they create the website lookup?
Well, I mean, that's to put it on the website's one thing, but how did they create that matrix?
Same way I did.
Oh, so then, like...
It takes programming to put it out there.
So our former treasurer can look up her parcels and know how much she would have to give to the general
If we get
fund?
the program that they are using on their website and feed the data tables that I have that are applicable to Calaveras, yes, anyone who's in Williamson Act could look it up with their assessor parcel number.
Okay. It can be done, we know. So is that like time-consuming? Is that...
It will take some time for me to get that
So, I mean,
code
how
from
do
those
we...
counties.
I mean, so I guess my thought is you can't communicate with the ag community unless they know, well, what is this going to cost me? And we appeal to the goodness of their heart to come up with $98,000 for the general fund, since we're not collecting $136,000 to the general fund.
Well, the other view of that is this. When Williamson Act first started, that $136,000 subvention wasn't part of the puzzle. Williamson Act started to preserve agricultural land. Subventions didn't come along until the next decade.
Right.
So the premise behind Williamson Act was always to preserve agriculture without a bonus to counties for having stepped up and done that. My choice was not to go rile the agricultural community with a proposal that may not fly depending on what your board decides. If your board decides that you want us to pursue implementation of this, then we'll go do the work that we need to educate the agricultural community and get that information out there. I'm really hoping we can kind of stop that today.
So am I to understand that not only would we be not taking in, we would miss out on $98,000 worth of revenue to the county, but Marita is saying that the county also puts out $50,000 a year in their budget to manage Williamson Act contracts. So really the total number would be $148,000 net?
No, you'd still have to maintain the contracts, so the $50,000 would still be expired. We're not talking about doing away with all the contracts. So we would still be expending the $50,000 to maintain the contracts. Is that correct? So you're talking about $48,000 actual.
Which number is it? I mean,
It just depends on how you want to move the shells, if you want to subtract or more. The general fund, let's be clear, pays the $50,000.
Correct.
The general fund also does not receive subvention funds anymore. We're not going to.
So in
So we're
reality,
paying out 50 and we're not getting 98, so that's
this-
148,000.
This 98,000 would help offset the 50,000.
Why would you have to pay the 50,000 if it was if the plan was suspended? Oh, it's just for the subvention. It's not the Williamson Act.
Yeah.
Sorry.
And
Okay.
unless we want to
So
suspend
that there would be.
contract.
So, okay, I got it.
and put
So there would be a
everybody-
savings of.
Now, if we say we want to put
48,000.
all of you in non-renewal, then there'd be a lot of people up here talking.
That's correct.
And we're not saying.
Well, actually, and I'm not sure that this has or hasn't come up in the other counties, if you decided that you were going to put everyone in non-renewal, I would certainly recommend that they go read R&T Code Section 426 that says that if they file a protest,
Yes.
we don't reduce their value until less than 6 years remain on the term, which means for 5 years, till you get below 6, for 5 years you wouldn't see a net change at all if they were to take the route of filing a protest.
No, I understood that. But long term, assuming we're not going to be seeing any subvention funds, that would then reduce that 50,000 because we would start that process. Understand what you're saying.
I understand it now. So if we moved forward with SB 683, the county would recoup $98,000. It costs us $50,000 to manage the Williamson Act. So the Williamson Act would still stay in place, however, with no subventions, and the county would be $48,000 ahead for our general budget. Williamson Act is intact. We just don't have the subvention piece in this process.
You would not necessarily be ahead 48,000. That 48,000 is net of the agricultural commissioner's costs. It's really important to remember that that is not the only department in the county that deals with the Williamson Act. And the reality of that is that I'm sitting here talking to you about Williamson Act. There is an awful lot of work that goes on in my department, and implementation of Senate Bill 863 would also require additional work in the auditor's office and in the recorder's office and possibly the clerk of the board.
At this point, I grew up in Manteca. You want to talk about you grew up, in the 1960s when it came, when this came around originally. I grew up in Manteca, and I watched that town evolve from 8,000 people when I was a kid, and a lot of my friends were dairy farmers and almond people and things like that, peaches and whatnot. And Mr. Race brought up something earlier that the Williamson Act is fine and good when people are of the mindset or the development isn't close enough to them that it works for them. But Mr. Ponte sat in here not even 6 months ago and said that he didn't want to have anything to do with the Williamson Act, so that he had the ability to develop his property in Valley Springs when the market came back up. I think he used some other explicatives, in his approach at the podium. So, while personally I feel that I think it's really sad what was done to my hometown, and I think that those lands should be preserved. And I'm glad that you separated it out today in the history of this, letting people know that the Williamson Act existed before there was any of these subventions to help offset some of the losses to the counties. At this time, I would not in any way want to advocate doing away with Williamson Act to help protect lands for ag. However, if the state is not funding those subventions and the community within the county is looking for the county general fund to offset the subvention loss that's usually given by the state, and the state's not sending us any money, I'm looking at that and saying, that's going to be some jobs that are going to have to be cut from our staff that's already cut, which people say it's been cut to the bone with 17.5% cuts for the last 3 years in a row. So to me, I really don't see that I could be in favor of funding subventions that the state is not paying for at the expense of cutting more people's jobs and forcing them out of their homes. Williamson Act would still be intact without the county subsidizing something the state's not paying us for. That's the bottom line. So the people that have the land that's in the Williamson Act have to ask themselves a hard, tough question that everybody else has been dealing with, which is, do I want to continue to be involved in ag if there's no subvention money?
Rita?
It's a personal decision.
No, I want us, I think we've made a commitment to stay in Williamson. We've made a commitment to accept new contracts. For me, that isn't the issue. The issue is, I think we need to look at where does that $98,000 come from by a parcel, so that maybe it's an education process, not only for me, but for the Farm Bureau or for the Cattle Association, for our ag community in the county. I mean, they understand where the county is. And this is, again, general fund money, and I would like to see us put that matrix together by parcel if we could, so they would know what that 10% meant for them per parcel. And the county's made a commitment to the ag community. I'd like to see the ag community consider, not saying that they will, and I'm not saying that, to consider the adoption of 863.
Done?
Done.
I guess I have a couple questions before we go forward here. One is, you said September 1st or September 30th. If we waited to bring this up and address it again at budget time in June, and we made a decision in June, would that give you enough time
to do what?
To get it prepared and implemented by September 30th in order to the notices to go out for that 90-day period?
Well, it would certainly give us enough time to send notices to landowners and for you to hold a hearing, and for probably everything to be done in September to get it recorded. Wouldn't you think, Mary?
I think it would. I know other counties
I'm assuming you're talking proposed budget or whatever we call it these days.
Proposed budget, that obviously, because until September 1st and whatever the state does. So if we waited till June or even May when we start talking budget, if we discussed it then, we would have enough time. The other thing is, you mentioned $98,000, but at the opening, you mentioned that there's 1,099 parcels affected, and you brought up 8975, but only 28 is a medium. But at 1,099 parcels and $98,000, that's close to $89 per parcel on average that we're looking at.
That is exactly the average. The average is $89.74 per parcel.
Yeah.
But almost half of them will be less than $20. And about 10% of them will be less than $1.
Well, I guess, when I first read this, and I was one that voted in favor of keeping the Williamson Act, and I'm still in favor of keeping the Williamson Act. I think it's a viable tool, a very necessary tool. And I know that ag here in this county is not exactly the same as ag in the valley, where they have the $5 premium parcel or acre charge. Ours is mostly $1, and I think that's where we got in trouble when we got audited. We were looking at the $5 parcels and counting them, the $5 acres, and counting them as prime, and they weren't. The fact that we would still be spending $50,000 no matter what we did here is an issue. I know it goes to 2015, but I'm not sure. This is another one of those house of cards that are being built in here. What happens after 5 years? Does it become permanent? I don't think there's any answers given out there. I'm not sure either the $10 million is off the table. I know it's being proposed. I know it's being talked about. But RCRC and CSAC were very instrumental in getting that $10 million put on there. I went to a couple meetings with CSAC over this particular item, and there was a lot of counties there. Jim went to one with me that we went down to Fresno.
I was there.
It was Jim and I that went.
Which one did we go to? We went to one in Fresno, too.
I think what needs to be done, since we have time, my opinion is I think we need to look at this at budget time. I would like to wait, and maybe we can get some more information between now and then. Maybe we can put up the matrix that Marita was talking about, and we can all look at what each parcel owner would be paying and have some discussions that way. Yes, Mary?
Supervisor Dolphinelli, in response to some of Marita's comments, I can say I did have outreach with some of the agricultural groups. When this bill was being introduced, I did speak of it with the Farm Bureau. And I can reiterate exactly what Leslie said. You know, Williamson Act is the preservation program for ag lands. The Williamson Act was in place before subventions. You'll hear it all again. The State Farm Bureau was supportive and actually pushed this bill forward. Our local Farm Bureau, in that conversation I had, did state that remaining status quo is the way that they want to stay. The California Cattlemen's Association took no position on the bill, and locally they also want to maintain the status quo situation in the county. If you're directing us eventually to go through and have the hearings and implement this bill, it's something we need to do every year. So every year we will have the public hearing. Every year we will have to send out the notices. It isn't one hearing and it's good for 4 years. It's an annual process we need to go through. And I have to admit, it kind of sounds like I'm somewhat ill, but I watched a couple other board meetings in Stanislaus County and Sacramento County when they were discussing SB 863, and the boardroom was full of ranchers that, there were a few that supported it because they thought that the program would go away, but it was full of individuals that did not want the program to go through, that they wanted to see a status quo program. And in Sacramento, the board did choose to keep it status quo. And I'm sure we will see that when we have these hearings. I'd also like to just mention quickly the $50,000 that everyone's talking about. Every year I need to submit an annual financial statement to the Department of Food and Agriculture. It breaks down how the Ag Department spends their money by program. And $50,000 of my budget, that means keeping the lights on, the pens, the papers, goes towards Williamson Act.
I think there's only one other thing to add to the arguments that we've made against implementing this, and that is this. I expect this to be litigated. You know, when you start talking about adding new taxes or fees, and you say if it acts like a duck, quacks like a duck, it's a duck. There are a lot of people throughout this state who are Williamson Act contract holders who did not support the Farm Bureau's effort to pass Senate Bill 863. When the Farm Bureau pushed Senate Bill 863, they truly believed that $10 million that was on the table would stay there, and certainly doesn't appear to be there now. And there's a lot of irritation about a perceived tax that is going on a tax bill without a vote of the public. That truly concerns me. I don't think Calaveras County is in a position to be a test case for something like that. So that's the other piece that I have not put out there that I just want you to be aware of. I don't know that it would be analyzed by proposed budget, but you should be aware of it.
Okay.
We
Anything
don't
else?
have to be. There's other counties already out there that have implemented it. So it doesn't mean that we would be the test case.
Well, we would probably be lumped in with those other 6 if we did.
Except they've already implemented it. We have not, because we've missed that one.
But there's no lawsuit been filed. Well, yeah, that's correct.
So you're suggesting that perhaps we could face a lawsuit along with the rest of the counties that implement SB 863 because of the real loss of revenue to the people who hold those contracts?
You know,
I'm not sure I agree with the because of part. I'm saying that what I'm hearing from a number of folks in other counties, because let's be realistic, just as you speak with your colleagues in other counties, so do we. I'm hearing a lot of rumble about potential litigation because of the way this was passed and whether or not it violates Prop 218 and that sort of thing. So I don't know. I'm not legal counsel, and I don't really want to think about putting Jim on the spot there. I just want you to be aware of the rumble.
So you're thinking because this could be, they would file suit on the grounds of that it was a breach of contract because they have a standing contract for Williamson Act to be reimbursed?
Howard Jarvis Association signed off on this. I mean that's just, since they're the anti-tax group, and I mean, does it run afoul of 218 or 213? The Office of Legislative Counsel said no.
Well, until a judge actually says
that's
something,
correct.
I don't care
Everything's
what
done
Howard
with.
Jarvis
But you know
Association
what? That comes to us all the time. Well, we're going to be sued. We're going to. You know what? Go at it. I mean, part of what we do is weigh that. For me, the issue isn't are we all going to be sued. The issue is I don't have enough information that, you know, if I'm going to ask Lynn Norfolk, would she be willing to give the county $89 or $28 to help offset a general fund cost that's costing to maintain a program that's of benefit to all of us? Would she be willing to do that? I mean, I pick on some of you others, but Lynn's brand new to the public, so I'm going to pick on her. So that's, I mean, that's it for me. I mean, what we're saying is we want the taxpayers of Calaveras County to subsidize this program that we have lost a considerable amount of funding for, to the tune of however you want to cut it, 98, 50,000, 48, what have you. And when we start talking at budget time of what we're going to cut, we're going to wish we had some of that money.
So is it your expectation that as part of the budget deliberations, you will give direction to staff to proceed?
Well, we haven't taken a poll or voted on that yet, so I was trying to head in that direction to give you some direction on where we're going to go with this. So I guess we should take a poll with the three of us to see if we agree on anything. Marita, you're saying that we should give staff direction to move forward?
No, yes, but not move forward to implement it, but that we need to have more information on what this is going to cost. So when we go and talk to the ag community, we can say, here are all the parcels in the county that are under the Williamson Act, and this is what it would cost you to, if we implement the bill. So, and we can discuss it at budget time, but way before budget time, I'd like to have that information to be able to talk to the Farm Bureau in Calaveras County.
So your recommendation to staff is to prepare documentation?
Yes.
Now, before budget, and then we can discuss this at budget.
We can discuss it with the ag community prior to budget. You know, we're all in this together as a county. We're just the ones that have to make the cuts, and you know, maybe it's not going to be worth it. You know, it's to 2015, and maybe we want to say over a 4-year period. I don't know if Leslie and Mary said it's going to be $400,000 to the county. I mean, maybe we want to say we want the general fund, the taxpayers, property taxpayers of Calaveras, to eat those costs, and that's fine. Let's just be open about it and say that's what we're going to do.
Darren, where are you on this?
Well, Marita brought up some good points in terms of the idea of subsidies. I sat in these chambers as a member of the public some months ago and heard deliberation where the board directed that the board at that time was not willing to subsidize CCWD continuing to dump sludge at Milton at Rock Creek for the amount that they had continued to dump it for, because it constituted a subsidy on the taxpayers of this county. The fee that the county was charging CCWD was not adequate to cover the amount that the cost incurred by the county to deal with that sludge. I see this issue as no different than that in terms of, it isn't a matter of whether or not it's a valid program, and I think that I've made my statement clear that I grew up in an ag community and I support ag. But when it comes to being an elected official in tight budgetary years, it basically comes down to what Marita mentioned in terms of it being a subsidy. We have to be honest in saying, are we willing to subsidize these payments that the state is not reimbursing us for at the expense of cutting jobs and services to every taxpayer in this county? That's what it comes down to. So I'm hoping that the direction that Marita gave, that we can come up with a document that shows the actual net that the county would be on the hook for if we decided not to implement SB 863. I want to know the actual net, not this minus this, but then throw that back in the pot and turn it sideways and multiply by 3 and square root of 60, whatever. I want to know. I want a document that shows the actual net of what the county is going to be subsidizing, quote unquote, if we allow the program to continue in its current state, because that's what it really amounts to. And hopefully I will get feedback, and the rest of the supervisors will, from between now and budget time from our constituents on what their thoughts are, when they have the actual net number of what it will cost the county, and whether or not our constituents, the taxpayers, feel that they're willing to foot the bill, not whether the board thinks that they'd like to capitulate and write checks.
So you're along the lines of Marita. Let's bring back some information that we can look at and go out to the ag community. Jim, I have a question for you. Since there's only 3 of us here, in order to give staff direction, we need to have all 3 supervisors agree on that. Is that correct? In order to give them direction, if one doesn't agree, then this dies.
I think the rule here is that you're not taking an action that binds the county to do anything. So staff will do whatever staff does based on the feedback that you give staff.
What he's saying is if there's only 2.
There's only 2 at this point. I'm wanting to know if 2 is enough to...
He's going to pull a Walensky on this.
No, Walensky left.
Well, then you wouldn't be able to give staff any direction.
We would not.
You can't give direction to staff to do anything in particular. They may choose to work on it or not. We would need to resolve the question for the other supervisors and see if they're able to participate.
Okay, I'll go along with. I'm not totally in favor. I'm in favor of preserving ag land, but I will go along with the other 2 supervisors and giving staff direction to come back to us with some documentation on what the dollar amounts are, and being able to post that where we can see the APNs and what exact dollar figure for each one of those APNs are. So we do have some more information for us to look at. And I'll leave it up to you to when to come back to us. Marita would like to see it before budget time. I would like to see it before budget also. Hopefully sometime around the first part of May or last part of April, if that's possible. or sooner.
No pressure.
After lunch?
I think we worked through lunch, Peter. So you should give us a comment